My lord, may I be permitted to mention on application for inclusion. New matter, my lord.
When is it returnable? Have you given her any returnable date?
No. This is on new machine.
My lord,
My
may I
lord-
be permitted to
Yeah,
mention?
just
My lord, maybe
Your Lordship, these are all analogous matters. 10 applications were part heard and were to be listed on 9th of October. 9th of October, it was to be listed.
so that is because of the
Yes.
reshuffling of the list and
Yes,
everything.
Your
Because
Lordship.
the bench broke.
Yes, Your Lordship.
Give it, but it will be after the
Yes.
vacation.
my lord,
But it's
may I
very
be
urgent,
permitted
Your
to
Lordship.
mention, my lord, one matter 215 of the monthly combined list of this month, my lord.
Yes.
I'm praying for upgradation, my lord, because my lord, contempt matter is very active.
When is the contempt?
Uh,
Have you given a notice to your other side?
I will give the. In the meantime, I will give the notice. No, my lord, the first time appeal, my lord.
It is a mandamus appeal.
Mandamus appeal.
It is then why didn't you mention earlier? It was in
My
the
lord, earlier I
convoy.
have mentioned, my lord, but the matter is not upgraded. That is why, my lord, I am praying.
When is the contempt fixed?
My lord, contempt bench is Honorable Justice Lopita Banerjee, my lord. And that bench, that means any time, my lord, the contempt matter will appear, my lord. That is why I am.
Give the slip, let us see. Give
May I
the
have your
slip with the number. Give the slip, write the number
Right.
thereof.
I
Yes.
have your lordship need to mention for inclusion, the appellant is apprehending from being dispossessed from the property.
All new applications, please give the slips. This is a service related matter.
No, this is not service. This is second appeal, my lord.
Second appeal, why you are
Uh,
mentioning?
Because this case was heard in full at length, but this my lord asked for some documents, work documents.
Second appeal.
Yes,
The bench has changed. We don't have the determination of second appeal.
lord has heard it at length.
So did we make it part heard?
Yes,
You are sure? Please ascertain and mention. Bring the last order so that we can ascertain it is time part heard or not. If it is not part heard, it will not appear before this bench. Please check up. Yes.
One order, extension of interim order
When is it expiring?
on 31st of December.
31st December.
Hmm.
So why you are in such a hurry?
Well, because
We still have 2 weeks of court.
2 weeks, well, before that it can be,
Is it in the list?
no, not in the list, in the order in the monthly list.
Mr. Mukherjee, give a notice to your
Yes,
I
no,
appear for the
perfect.
respondent.
You're for the
I'm
rest.
for the respondent in that matter.
Now, extension of insurance.
Lord,
Your Lordship, may I be permitted to mention one matter? This is relating to Group 6, whereby the Honorable Single Judge.
All slips, please hand over.
my lord, Group 6 original site.
Grateful to your Lordship.
Original site.
Original site, my lord.
You give this slip. This is a fresh application
The 2023 appeal, fresh appeal for admission itself.
for WPCT or service.
Service.
It is
Service
not-
read.
মিঠুনের সাথে
Group
কথা-
6. Against the
May I pray for
Grateful, my lord.
Lordship leave, my lord? This is a matter WPCT running your Lordship list. I want to file a CAN application related matter. My lord, the petitioner
Which is the matter?
uh,
Is it appearing in the list?
yes, my lord, my submission is the petitioner is residing at North Bengal, Siliguri. What I am praying for from Lordship is only notary affirmation.
That is not our duty. You ascertain from the commissioner.
My lord, I have done that. They said that relevant there is leave should be obtained from the relevant bench. That's why I am approaching my lord.
Leave for what?
For instead of oath commissioner, I want to file the application on the basis of affidavit on before the notary.
That cannot be done.
Lordship, your lordship
Rules
can, my
will
lord.
not permit.
The petitioner is residing in Siliguri and his mother is coma at nursing home. That's why I am.
Very good. Let the matter come. Let the matter come. You then tell us.
Oh,
My lord, lordship leave want to mention one matter, my lord. Although I appear for the respondents, my lord, the state preferred a writ petition, and I preferred a contempt before the tribunal. My lord, when the rule was issued, state preferred the writ petition. My lord, the writ petition got dismissed. My lord, I went to the tribunal and said, now the writ petition got dismissed. My lord, your lordship takes it up. The tribunal takes it up. My lord, at that juncture, they say we have filed a restoration application. The fact remains at that day they have not filed. Later on, my lord,
What do you want?
but I want inclusion in the list, my lord. My contempt becomes infructuous. I'm going to return in the next month. I got the,
We didn't follow. You
my lord,
preferred
I approached the tribunal, my lord. Tribunal directed me to promote me.
against that they came up in appeal.
My lord, thereafter, nothing happened. I filed a contempt petition.
Hmm.
Rule was issued. The very day when the rule was issued, next day they filed a writ petition.
Very good. Now, what is the status of the writ petition?
Writ petition got dismissed, my lord. Dismissed for default. Now, my lord, they filed a CAN, and every time they come to the tribunal and saying, yes, we have filed a CAN application, is pending unless, and the tribunal, my lord, as
That is for you to convince the tribunal.
But
When the matter is not on record, tribunal has every liberty to proceed with
my lord,
this.
your lordship will find the orders of the
You
tribunal.
cannot correct that, sir.
No, well, I'm basically,
Restoration application they have filed when? Have you got a copy?
yes, my lord, copy has been,
So survey notice.
I have
about
served
it.
notice, my
Who
lord.
is your other side advocate?
My advocate is Amrita, just my lord, Amrita Paja Maulik. I have served notice upon her, my lord.
Which bench passed the interim order?
My lord,
Was any interim order
no, my
passed
lord, there's
there?
no interim order, nothing, my lord, but still the tribunal is not
Then
processing, my lord.
tribunal doesn't- What we are doing. You have to take steps before the tribunal.
Well,
sir.
I have
Petition-
time.
We cannot call them and say restore the matter.
No, my lord, only thing is this, my lord, your lordship, that,
You please ascertain the ways and means because that will be more prejudicial to you.
no, my lord, the tribe,
If the restoration application is allowed, then they will be praying for a stay.
my lord,
They will be praying for a stay.
but if the writ petition is admitted, then the question of stay would come. In my case, my lord, I can with all, as per my understanding, my lord,
That is not your child, it is their matter.
that's true.
You
my
are
lord.
being worried. Your remedy is to go to the tribunal, tell these facts. And tell these facts that the writ petition is not even on record. So where is the bar in proceeding with the contempt?
My lord, only problem is
Sorry,
this, my lord.
sir. Yes.
My lord, only lordship, your lordship kindly consider, my lord.
We have considered.
There is only one member, and that is administrative member, my lord. He doesn't have this.
Sir, these complaints towards would not suffice. Na? You have to take the available remedies available.
But
which are-
I have tried my level best, my lord. Tribunal is not listening to me, my lord.
Let us see when they come with the restoration. Yes.
My lord, may I permit to mention the matter? The urgency is by an order dated 6 November 23, the Honorable Supreme Court requesting to decide the matter within the 3 months, and the 3 months is expired 5th February 24. Let the matter be included in the list at earliest. This is service matter, my lord.
6th November, it was heard by the Supreme Court.
Yes, my lord.
So we are today on. What is the date today?
Today, 11th, the 11th.
Then you are mentioning after more than a month. You are the petitioner.
Yes, my lord.
Where is the Supreme Court order?
I have annexed, my lord.
You see the Supreme Court. The judgment is pending for 3 months. Where is that it should be considered within 3 weeks? See, they come and tell us after 1. Let us see what can be done. এটা লিখে রাখো।
Thank you, my lord.
Is it in the list? Is the appeal running
my
in
lord.
the list?
Yes, yes,
Which
my
is
lord.
the item?
Item number
ওটা ফেরত দিয়ে দাও। Ascertain and come and tell us on Thursday.
Thursday.
Who is your other side? Have you given notice? Give a notice
yes,
to
ma'am.
the other side and ascertain the date. What is the number in the combined list and come and tell us on Thursday. Yes.
My lord,
Yes,
this
please.
is
Thank you.
application restoration, my lord.
All applications, please hand over.
I am praying for upgradation, my lord.
Sorry, no upgradation.
My lord, respondents are aged about, all the respondents are aged about 70 years.
Come and tell us, remind us on the next.
I pray upgradation, my lord.
Sir, come and remind us.
Very sorry, my lord. Previously, I also mentioned my lordship is directed to some delay, my lord.
Which is the item?
Item number 177, my lord. I am service notice, my lord, or other side, my lord. For a comment, my petition is suffering, my lord. His medical indicator, my lord. Payment is held up, my lord. Since long, my lord. It is very suffering, my lord. Kind,
No, hand over the slip
Yes.
letters. Have you mentioned the serial number?
yes, my lord.
Yes.
Kindly
Your
please,
Lordship, may I be permitted to mention serial number one?
We cannot ascertain just now. Let us see, we shall check up.
yes.
Your Lordship, may I be permitted to mention serial number 187 of the combined monthly list, my lord?
For
This is-
upgradation.
No, my lord. This is an Group 6 appeal relating to the year 2021, your Lordship.
Hmm.
This matter was heard by your Lordships before the annual vacations, but subject to correction, Lordships, perhaps this bench does not have determination on this date, your Lordship. Because your
It is a group 6 matter.
Group 6 matter relating to the year 2021, your Lordship.
We do have the determination.
Your Lordship, subject to correction, I believe, your Lordship.
2022 onwards.
So, your Lordship, if
All right, we shall release it. Yes. To be mentioned there. Yes.
May I permitted to mention?
Have you given notice to your other side?
no, sir, no, your Lordship, I shall serve in the course of the day, your Lordship.
In their absence, it cannot be done.
I shall serve.
Your Lordship, may I permit to mention a matter, hearing matter for inclusion in the list? It's a group.
Combined list, yes. Yes, what you have
May I
mentioned.
be permitted to mention one
Huh?
matter? This matter is about WPLRT matter, my lord,
Yes.
and it was for expeditious disposal, my lord. It was lastly appeared in the monthly list of January 2023, my lord.
So what happened? Is it still
has
in the
gone-
list?
It has gone out of list, my lord.
So you must not have appeared. That is why it has gone out of list.
Due to some
Mention, you remind us next monthly list. Yes.
Sir.
Remind us when in the next month you remind us.
My lord, I have a,
When was it sent out of list?
in the month of January, my lord.
You don't know the date also, see. Where is your notice to the other side?
Lord, we haven't
Give
served any-
notice and come back and mention. Yes, Mr. Ghosh.
Lord, I am mentioning one matter, Lord, in this matter. Lord, the 38 parcel porters are directed to be absorbed in the regular service of Eastern Railway Malda. Lord, after order was passed within specific time limit, it should be cut because if they attain majority,
Is it in
it is in the list, Lord.
which is the
Lord, I have given item number 167. My Lord, last occasion it fell from my lords that the matter would be maybe mentioned after the list is published, monthly list is published. Lord, I have given notice to the other side.
it is already in the combined list.
Yes.
But
And
Mr.
Lord-
Ghosh, we do not think upgradation would be possible.
Lord, otherwise, Lord, if they attain Lord, the age of majority, superannuation, then Lord,
When is the superannuation?
Lord, 1 year or 2 year left. But before absorption, if
Please
that's-
wait, Mr. Ghosh.
Lord, there was a direction of affidavit. We have completed our everything. They have not yet.
It is
6 months have passed. Railway has not yet.
Mr. Ghosh, it is already in the list. If it is not reached
Look.
by the next month, please come and
Lord, kindly do some favor. Lord, otherwise I would not have
here, there,
vexed your lordship kindly.
but we cannot say that it will be upgraded. It combined list আছে দেখে নিও। Yes.
My lord,
Lord, this matter was heard some company report was called from Fisheries Department regarding land matter by Justice Lord Bosak. Your lordship kindly. Let me back. Yes.
sir, my lord, I have a small prayer.
You have anything mentioned?
I
Yes,
mentioned.
tell.
Petitioner does not getting pension since till date.
Which is the matter? Is it in the list?
No, out of list.
So where is your slip? Where is your mentioning? What is that? It went out of list.
Out of list.
It was sent by the previous bench out of list.
Yes, department file is the department.
Uh-huh.
File is a department. Yes.
Check করে নাও তো কি বলছে। Yes.
My lord, I have a small prayer to you. Sir, I am retirement at the remaining 5 months. 5 months. This case is WPCT 457 of
Where is your advocate?
Sir, there is no available money for maintaining mentioning time to
Have
time.
you executed any wakalatnama in favor of any advocate?
Sir,
Do you have an advocate of yours?
Yes, sir.
Then why you are mentioning?
স্যার মেনশন করছে না স্যার, আমার খুব অসুবিধে পড়েছি স্যার, আপনার কাছে কাইন্ডলি
কে অ্যাডভোকেট আপনার?
পূজা বেরিয়াল।
তো কেন মেনশন করছেন না?
আমি টাইমটা বলছে ফেল করেছি স্যার, এটা আগে
সেই জন্য আপনি চলে এলেন মেনশন করতে?
স্যার আমার খুব মানে আমি রিটায়ারমেন্ট
সেটার একটা প্রসিজিয়ার আছে।
স্যার।
আপনাকে ওকালতনামা তাহলে উইথড্র করতে হবে। আপনি যদি ইন পার্সন অ্যাপিয়ার করতে
না না
চান।
স্যার, আমি তো সার্ভিস করি, আমি তো যদি অকলাতনামা কখন উঠবে আমি তো করতে পারবো না। বলছে মেনশনিংটা হয়ে গেলে আমি তো স্যার কি করে করব, এটা একটু আমাকে গুড
মেনশনিং হয়ে গেলে
আর যদি কেসটা উঠে যায় তাহলে তো আমি আর থাকতে পারবো না, যে জন্য দেওয়া আছে। কিন্তু আমার খুব আর্জেন্ট স্যার আছে, 5 মাস আর চাকরি বাকি আছে।
আপনি অ্যাডভোকেটের সাথে কথা বলে অ্যাডভোকেট বাবুকে বলুন মেনশন করতে। ইয়েস,
এইটা স্যার এইটা করা ছিল, পুজোর আগে করা ছিল, মেনশন করা ছিল, কিন্তু ওটা
আপনার
অ্যালাউ হয় না স্যার।
আপনার অ্যাডভোকেটকে এসে মেনশন করতে। ইয়েস,
My lord, this matter, my lord, it is a second appeal, my lord. It was assigned to my lord's bench, my lord, by my lord Harish Tandon, my lord.
করে নাও অ্যাসাইন।
It was
It hard.
my lord, it was taken up, heard, but my lord wanted to see the lower court record. That's why my lord didn't admitted the appeal. It is second appeal, my lord.
Second appeal admission, we didn't have the determination.
My lord, it is a assigned matter. It was my lord, in June, prior to June, my lord had determination. My lord was sitting in court number 32, my lord.
So what makes you to come and mention suddenly? When was the assignment made?
Long time back, my lord. It
So
was
why
running in the
didn't
list, my lord.
Pardon?
It was running in the list, my lord.
Which list?
My lord's list, my lord.
Which date?
My lord, it is running in the monthly list also, my lord. I have to just check up with the number. It was there, my
Sir, it is your, madam, it's your duty to check up and mention. It is not our post to check up the list from here.
My
Please
lord,
ascertain where it is in the list, then come and
my lord, it
mention.
was running in my lord list, my lord.
Which is
After
the
puja vacation, my lord, it is not running in the list, my lord. And I'm praying for urgency, my lord, to admit my appeal.
দেখে নাও assign কি না।
Assign, my lord. It is showing in that CIS is show. it's
Hand
showing
over
that.
the slip. It is your other side.
My lord, other side was not appearing, my lord.
Your lordship, kind leave to mention one hearing, senior citizen lordship. Senior citizen.
Hearing it will come in the combined
And-
list. Yes, call the
Lordship,
list.
One another lordship. This is a contempt lordship, assigned matter lordship. First of all, it has a determination of Justice Girish Gupta. He has
We
retired.
don't have the determination, sir. Contempt of judges who are not there, it has been assigned to one particular bench.
Lordship, it has assigned to the regular bench lordship.
Assigned to the regular bench. There
Regular
is no such assignment order to that effect. Please check up the list. There is a caption that for contempt matters in respect of the honorable judges no longer available, it will go before a particular bench. Please ascertain from the list, then come and mention. Yes, go.
My lord, my only request, my lord, police help is on the urge execution, my lord. To hear it, my lord.
Yes, any further mentioning? Call the list.
In this matter, I beg to appear on behalf of the
Assign, suppose I will clear the matter legally. If the bench breaks, then though it is assigned to me as a senior member, I have to again it with a junior member.
matter, I beg to appear on behalf of the petitioner. This is my affidavit service.
Affidavit of service, why they are not coming?
No. Invitation একটা কই?
বাধা আছে তো
কই, কই,
বাধা আছে।
কই?
ওই পেটের মধ্যে বাঁধা ছিল,
কই?
বাঁধা ছিল, তাহলে টেবিলে খুলে নিয়ে আসবে। Have you served, Mr.?
Yes, but it is return answered. So far as petition number 2 is concerned. May I tell you also the short facts? An original application was filed before the learned tribunal in 2006 by 2 employees, affirmed, verified by applicant number 1. He died in 2011.
No, Mr. Mukherjee, we will hear you.
Yes, but just for a technical point.
No, please tell us whether these heirs have been served.
Yes,
The-
yes have been served. Yes have been served.
It is coming for the first time, no?
First time.
So who was the advocate in the tribunal on their part?
Can you see the order? Mr. G.P. Banerjee and S. Chatterjee. May I tell you also a very short fact? Tribunal
Yes.
application was filed in 2006. Verified by the
Just which order you are challenging?
telling the order dated 8th December 2022.
8th December.
December 2022. They have filed an application for substitution after 8 years, 11 months. That application for substitution was withdrawn. The liberty was given to take steps. No steps was taken. Then, for the final hearing, the direction upon no verification took place. Then, order was passed in abated proceedings. Whether the tribunal has got jurisdiction to pass such an order.
লিমিটেশন অ্যাড করছেন
হ্যাঁ
বলেছি আনতে
কতবার বললাম রে ভাই বইটা না kindly see at page
দেখি সার্ভিসটা দেখি।
death certificate at page 74.
Wait.
কোথায়
without address, but I already filed that contempt application.
But they have already filed a contempt applications.
দেবাশিস লাল।
Please stay on.
What you are saying? Where is your service our Nomita Dhabok, Onimesh Dhabok and Amores Dhabok?
না ওদের তো সার্ভিস করিনি ওদের তো
Mr. Mukherjee, you
They
do
have
not,
not been substituted as yet till date. They have not
you have made them parties. In the writ petition, they are parties.
because they have kindly
Do not know that. Have you served upon these three persons?
না না ওদের উপর সব করিনি
because they have not been substituted.
Mr. Mukherjee, you make a person a party. Whether he was substituted or not, we will decide later, but please serve. Let them know. Mr. Mukherjee, learned AGP appearing for the petitioners, prays for an accommodation to complete service upon all the respondents.
আর একে কি সার্ভিস করবো এটা একটু জিজ্ঞেস করে নিন না
Okay.
এই যে ওরা করেছে 4/12 ছিল
Please the matter for further consideration.
CCP 70
Please the comma, leave the
CCP
matter
70
for
ওখানে সল্ট থেকে স্ট্র্যাটেজি
for
গাড়ি
further
ছিল
consideration in the daily supplementary list of this court on 9th January. Yes. Take back this affidavit of service.
May I permitted to serve the copy of the application upon the learned advocate who appearing in the contempt applications?
If after service nobody appears, then we shall consider. Affidavit of service.
আচ্ছা
Limitation একটা কোথায় গেল? বলি না কেন সার্ভিসটা?
সার্ভিসটা তো আমি দিই সার্ভিস করবো না
I am for the respondent.
Your Lordship, I am appearing for petitioner, learned counsel, senior advocate appearing for this case is seriously ill and he is not able to present before this case today. This case may be urgent for 1 week. He fell down and he is not recovering till date today.
An
All
adjournment,
right.
an adjournment has been prayed for on behalf of the petitioner,
Mr. Apurva Ghosh.
on behalf of the petitioners, though Mr. Chatterjee, learned advocate appearing for the sole respondent,
Yes, my lord, sole respondent.
is present. release the matter for further consideration 2 weeks hence.
Much obliged, Your Lordship.
Any supplementary list? Any date for supplementary list?
Pardon?
Daily list, any daily list, let it be appear in daily list.
Release the matter কি লিখেছো কবে? 2 weeks তো ছুটি পড়ে যাবে না?
Yes.
Consideration on
3.
January.
3.
Yes.
My lord, I'm sorry to submit that I'm praying some more days time to make myself prepare this matter. Actually, this matter, eh, eh,
Even my counsel is sick, he is treated in a hospital. Matters of this. We are here to accommodate us.
Okay.
Just now it was mentioned you see 11 matter out of list. If you cannot enter the group, immediately matter. Sir, what is this? So that's also not trying to be. Needs to judge what is right and what is wrong. Very much. You will find disposal drives are your point. Your disposal. Yes, that is. I will show you. I will show you lists where matter starts from 1 and mine within an hour or so 96 is gone. Is it possible for any judge to dispose of anti matters? Here on myself.
your lordship may take it up this matter, my lord.
Not this week,
Grateful to your lordship.
or 2 weeks. Come after 2 weeks. What is the urgency? What is the matter about? Tell us.
Matter is revision of pay, my lord, pensionary benefits, revision of pensionary benefits.
Revision of pensionary.
Pensionary.
What did the tribunal say?
Rejected.
They rejected your prayer.
Reject dual charges allowance, was prayed for dual charges allowance. Dual charges allowance was given, but that in revision, while pensionary benefits basic pay is revised, dual charges pension for the dual charges allowance that has not been calculated, that has not been considered.
Dual charges.
Yes.
What is that?
Dual charges allowance, 2 types of deputy CPO. Petitioner was deputy CPO.
It was hard on exchange of affidavits.
It was heard before the tribunal.
No, upon exchange of affidavits.
Yes. Upon exchange of affidavits.
So have you filed any? There is no scope for any interim.
No, interim order is not required at this stage.
Let us- You are not prepared. We are getting prepared. Mhm.
Actually, I am not prepared because of Mr. Chirodip Sinha told me that he would do, but he's not able to come, and that's why I.
Lordship, if your lordship comes to page 8 of the order, the facts are all,
No, it was not on exchange of affidavits. Tribunal matter.
lordship, the reply I
Exchange
don't
of-
find.
Perhaps they have, my lord, reply has been filed in tribunal, but rejoinder has not been filed.
because it's not annexed to the writ petition. But now reply to আমার reply টা আছে?
You have no track. You don't know whether 1 week after vacation. Yes.
Month. 1 week after. Any date is
An adjournment has been prayed for on behalf of the petitioner, though Miss Alam Learned Advocate appearing for the respondents is present. List the matter 1 week after the vacation. Yes, next.
Lordship.
Item number 4.
My lord, item number 4, I appear for the petitioner. My lord, this matter, my lord, factually, my lord, I am prepared, but I need to see, my lord, go through the legal aspects
Have
of
you
it.
served?
Yes, my lord, pursuant to your lordship's direction, we have served, my lord.
Any scope for any
No, no, no.
order?
Removal of the incumbent on the ground of theft, subsequently acquitted by the learned trial court. Same complainant, same facts.
Just a moment. Punishment order was 2008.
8 and acquittal in the year 2013. By this time, the petitioner retired. On the self-same complaint, self-same.
So that the tribunal has held against you.
Yes, my lord. Hence, my lord, I was as with regard to their appearances, my lord, they have not turned up. Neither they have filed any affidavits with regard to that. But with regard to the law on this subject, my lord, I was hence beseeching your lordships for a week's time so that I can appraise your lordships with regard to the.
What is the law, sir? Your tribunal has held the charge against you in the disciplinary proceeding is not similar to that in the.
No, my lord, I shall show also from the facts also that the charge were similar.
Did the tribunal, when did you approach the tribunal?
Well, to 2030, my lord, it is 2017.
17. And your
2017.
termination was 2008.
And my lord, acquittal in the year 2013. Thereafter, I made representations, my lord. Order was passed to that effect, my lord.
Now you have retired.
Retired. By this time, my superannuation age has come, my lord.
So you are getting, you have been terminated. You have not
Terminated.
getting
No,
any pension.
nothing, nothing.
Nothing remains in the matter. Nothing remains in the matter.
My lord, I was with regard to the legal aspect of it, my lord, as has been held by the tribunal, my lord. I was requesting your lordship so that it can be
1 week after the vacation.
grateful, my lord.
Take back your affidavit of service.
Grateful. Well, I have tried to check up the law. It's basically against me, my lord. So hence, I was requesting.
Fine, my lord, I am appearing on behalf of the petitioner led by Mr. Rohan Banerjee in this matter, my lord.
Mr. Manas Kundu is appearing for the writ petition. I actually on his behalf.
Appeared first time.
Previously, it was appeared on Friday, my lord, and it was on Thursday, my lord. And
At the application, section 5
application
is there.
section 5 is there, my lord.
How many days?
32 days delay, my lord.
Delay.
Even copies.
Yes, your lordship.
I have served, my lord.
Yes, my serve, your lordship. Your lordship,
It
kindly.
is your senior.
Your lordship, he's on legs before court number 759.
What is the matter about?
My lord, it is a disciplinary process. They have challenged the disciplinary action which was initiated against the writ petitioner by the South Bengal State Transport Corporation. Allegation is the money defalcation. That is the one.
What was the punishment given?
There is no punishment given. They have challenging the charge sheet. They have challenged the charge sheet, my lord. And initially, the Honorable High Court destined us to proceed to issue the final order.
All right, come next week, not
My
this
lord,
week.
on Friday, the contempt is pending. Fixed is on 15th, my lord.
Then come tomorrow.
Yes, not to
Wednesday,
day
my
after
lord.
tomorrow. Day after tomorrow, my lord.
Your limitation has to be allowed, no?
Yes, my lord. Actually, my lord, Mr. Oyon Banerjee leading me in this matter. He has some personal reasons tomorrow, my lord. For such reason, I am praying, just praying.
Day after tomorrow.
I beg to appear on behalf of the respondents appellant that the state is appearing and the private respondent is also there. I have served. But this is
Respondents served.
read petitioner, yes. This is my affidavit of service.
Edit, edit party হয়েছিল।
Okay. Whether the subject matter of the writ petition,
Tell me,
আচ্ছা, আচ্ছা।
is this point similar to that of Bono Sahayok matter?
No, 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 no.
That residence has to be within the jurisdiction of
But the Bono Sahayok, I do not know about the restrictions in the Bono Sahayok, but here the jurisdiction clause is not the resident. Jurisdiction, the recruitment notice says that the candidate must be the resident of the district or the region. But there is single judgment that interpreted the jurisdiction of the CWC. Not just kindly straightway comes to the notification, not the page 50 of the section 5 application. Can you take my section 5?
Section
There is
5?
section 5 because subsequently
How many days?
290 days delay. I have explained because the learned advocate was Satyajit Mondal, he was entrusted.
You are for the state.
I'm for the state.
There is some urgency why I'm pressing that because subsequent to the judge's order, my appointment has been cancelled and fresh selection process has been initiated. That's why I'm pressing. Kindly condone my delay.
Where is your service upon the private?
I've given the every service. Hey, every service to
you have served the section 5 application.
Everything is there.
Everything on do not give vague answers.
No, all.
Have you served the
But
section 5?
I have served the entire copy, but unfortunately, my junior did not mention in the letter that section 5. He stated that memo of appeal stay. That I must be candid, but entire bunch has been served. But may I serve? Yes, but I cannot serve. I that letter should contain that. He's mistake. Not I may serve one second section 5 application.
Have you got that section 5?
The section 5 is
Bunch in the same bunch it has been
Where
served.
is the section 5 application?
But this is can 1 in regard to 9 mat number 1931.
How many private response? Only
But
one?
only one writ petition.
The writ petition.
Because on the basis of hard writ petition, my appointment has been cancelled. And one of the candidates was also not a party in the writ petition. The second matter, he filed special leave to appeal.
Your appointment has been cancelled.
Cancelled. By virtue of that is
Now a fresh notification.
fresh notification has been, and I have prepared a supplementary affidavit. Also,
You are participating in that.
no, because I'm not the challenging. I'm not participating.
Affidavit of service filed by the petitioner does not reveal that service of the section 5 application, service of the applications.
চিঠিটা ঠিক করে দেখিস না সেকশন 5 লিখতে হয় চিঠিটার মধ্যে why didn't you write that
Affidavit of service
প্রথম
do
থেকে
not
আমি
reveal
বললাম
that service of the section 5 application upon the private respondent is complete. উপরে লিখে দেবে এভিডেন্ট অফ সার্ভিস ফাইল বি কেপ্ট অন রেকর্ড তারপর এভিডেন্ট অফ সার্ভিস ফাইল বাই দি পিটিশনার বি কেপ্ট অন রেকর্ড পিটিশনার্স হবে না অ্যাপেলেন্টস অ্যাপেলেন্টস বি কেপ্ট অন রেকর্ড
দুজন
does not
ওটাতে দুজন এডিট ছিল একটাতে তোমার পরের ম্যাটারটাতে স্পেশাল পার্টি ছিল না
তো মিস্টার you are for
I'm for the state respondents. All the state respondents.
তাহলে list the matter for further consideration on 24th on 22nd December. Stop.
22nd December.
The appellants are directed to survey copy of the section 5 application upon the private respondent. In the meantime, and to file an affidavit of service.
Kindly grant me to leave to file supplementary affidavit. This is a fresh notification afterwards, my lord. Kindly grant me leave to file supplementary.
Let us, you prepared the
My lord.
supplementary evidence, let
I'll
it
serve.
appear.
I'll serve to all of these.
Serve upon-
Well, can it be after vacation?
No, my lord, there is some urgency, my lord. My lord.
Section 5, most probably he will say, I will file a reply. We will make it return.
My lord, my lord.
The
My lord,
fresh
20
election
seconds.
process 24th December. 24th December, that's right. Before that, your lordship is taking up this
You
one.
can participate in that.
My lord,
My lord. What is the problem?
my lord, if my appointment remains, my lord, if the Rani Singh judge's order is set aside, my lord, then my appointment will be revived. That's it. But then I will be able to satisfy, perhaps not subject to correction.
Come back,
My lord.
satisfy. We
My
are
lord.
here to be satisfied.
My lord, my lord. I will try, my lord, on 22nd.
Now, my lord, subject to correction, if I am to address your lordship on the fresh notification, then copy of this supplementary affidavit needs to be served upon me.
Definitely.
Because
Supplementary
if
affidavit, I adding in advance, I'll serve.
new selection process is initiated,
today, my
either
lord,
it
it will
gives
be
rise a fresh cause of action for filing a writ petition,
No.
or, my lord, if my
No,
learned
this is
friend wants
subsequent
a
event
stay,
during the pendency of the appeal.
then, my lord,
That I served. Your lordship consider at the time of hearing.
the supplementary affidavit needs to be served.
Definitely, I'll
my
serve.
lord.
Definitely.
Where is your supplement?
My lord, this is. It is change your sharp. It will be affirmed.
Affidavit of service
Ah.
filed by the petitioner. Appellants be kept on record. Mr. Son naam likha.
Moloy Dhar, my lord.
Mr. Dhar, learned advocate appearing for the appellants, files a supplementary affidavit. Stop. Let the same be kept on record. Stop.
No.
The affidavit of
Okay.
service file does not reveal that service of the
Service code.
section 5 application upon the private respondent is complete. Stop. In view thereof, leaves the matter for further consideration on ATO. The petitioners, the appellants are directed to communicate this order along with the section 5 application. The appellants are directed to serve the section 5 application and the supplementary
My lord.
affidavit upon the private respondent number 7 in the meantime, and to affirm an affidavit of service on the returnable date.
Obliged.
We supplementary files as a copy of the same has been handed over to Mr. Learned Advocate for the respondent numbers.
My lord, respondent number 22, my lord, 125.
এক থেকে 5
6.
1 to 6, my lord.
1 to 6.
না ওইটা আমি অ্যাফার্ম করে দেবো ওটা অ্যাফার্ম করে দেবো
কোনটা?
অ্যাফার্ম করে দেবো অ্যাফার্ম করে দেবো
আমাকে একটা কপি দেওয়া
হ্যাঁ, আমি
ম্যাটের
আজকেই দেবো।
ম্যাটের সম্ভব?
ম্যাটের
হ্যাঁ?
দিয়ে দেবো
You have not affirmed.
No, just today, my lord, it will be affirmed. That's why, my lord, I said I prepared. I pray your lordship's leave to.
Then you come on that day.
My lord,
Why don't you tell us?
Well, that's why I said I prepared that I'll.
You have not even affirmed it. We will give you leave to file.
My lord, unless your lordship's leave, my lord, I cannot. I can affirm, but sir.
When can you come after affirmation?
Today itself, I can affirm. Today itself, I can affirm. I just prepared. Today itself, I affirm.
When are you going to affirm it?
Today itself, today, my lord, right now, within 1 hour.
Your client is here in court.
Yes.
এই অর্ডারটা সই হবে না, ওইটা
My
অ্যাফার্ম
lord,
করে
my lord.
দিলে অর্ডারটা
My lord. Affirm, after affirmation, I will just serve the copy.
unless you give to
Absolutely,
my court
absolutely,
officer
my lord, I
by
bow down.
12 o'clock.
I bow
You are
down.
not signing our order.
I bow down.
Yes, next.
আমি
Even not the same thing, but here not the special leave to appeal. The appellant was not made a party,
এইটাকে
but there is no section 5 application because the knowledge came subsequently. I did not file section 5.
already it will appear on that
Along
day,
with this
22nd, along with that.
Same order.
No, we are not passing any order. Let it come on that date. You are representing all, not the private respondent.
No, not the private.
All right, come back on that date. Yes. Who is your other side?
Mrs. Srimati Shushmita Shahadatto. Your Lordship.
Did we hear this earlier?
Yes, Your Lordship. It was heard and they were,
Bench.
yes, your lordship. No. Honorable Justice Parthasarathi Chatterjee was there, your lordship, but it was not a part-heard matter. They were directed to produce few documents.
What is
by your
this
lordship.
review application you have?
A review application was allowed, your lordship. My application was dismissed by the Honorable Division Bench in 2018, against which I had filed one review application, and it was allowed. And it was found that both the points which were raised by the respondents at the
It has
time
come
of,
for final hearing.
yes, your lordship.
Come after vacation.
Your lordship, this fellow is an unemployed person and he has been
You are
struggling
giving it
very
after
long.
the vacation.
Because,
On a particular date, you see the
Your
effect
lordship,
service upon the respondent and come.
Usually they take long time, your lordship, on
Wait,
every
wait.
date. They used to delay this proceeding. Even in the review application, they took 1 year. They always avoid the court proceedings, your lordship. So some strict orders may be passed so that they may, if possible, in the next week, your lordship.
4th January regular. You effect service, give an intimation that it will appear on 4th. Yes,
Your lordship, some order may be passed so that it may appear, or else I have to mention.
already an order is there, no?
But it doesn't appear if some order is not passed, your lordship, and I have to mention it again.
No one appears today on behalf of the respondents, though Ms. Shahal and an advocate appearing for the petitioners is present. To give a further opportunity to the respondents to appear and contest, the matter stands adjourned. Please the matter for further consideration on 4th January.
Lordship, I am for the petitioner, Your Lordship, BSN.
Petitioner?
Yes, Your Lordship. I'm challenging an order, Your Lordship, passed by the Central Administrative Tribunal.
Item number 11?
11, Your Lordship.
Who is opposing you?
Lordship, I mentioned the matter earlier, it came, nobody appeared. So I mentioned the matter. Your Lordship directed the matter to be listed today. I have, Your Lordship, served the copy of the notice to the other side. My problem, Your Lordship, they have filed a contempt against me before the Central Administrative Tribunal, and it is fixed on 15th. Now, Your Lordship, an identical matter, Your Lordship, has already stayed. Your Lordship, an order where the interpretation of Your Lordship Rule 58.
So you were waiting for the stay to be passed in the other matter. This is a
2020 matter, but they have filed a contempt. Now they are proceeding with the complaint. They have given me the last opportunity, Your Lordship, either to move before the Honorable High Court or they will proceed with the contempt. Identical matter, Your Lordship, kindly sees once. Sir.
You did not pray for any stay earlier. On the contrary, you prayed for adjournment.
Lordship, on that date, the other side was not there. My junior was there.
Which date, sir? It was last heard on 28th April 2021.
Lordship, that is
when had you served?
Lordship, recently, Your Lordship, I have served. I mentioned the matter. Then after, Your Lordship, I have served the notice. Lordship, kindly take, Your Lordship, the affidavit of service once. A copy then, affidavit of service.
Last heard on 2021. Thereafter, data suddenly came up after the content was filed.
Copy nahi. Affidavit of service, sir. Order copy.
That was a 2023 matter in which we bust.
Yes, Your Lordship. I have given Your Lordship the copy of the order. Your Lordship, the main, Your Lordship, the interpretation which is required, Your Lordship, that is Rule 58 of the BSNL Rules 2006. Your Lordship, whether Your Lordship, it has a retrospective effect or not. Lordship, first page, last paragraph, Mr. Bashu, learned advocate for the petitioner, respondent number 2 in the original application submits that the learned tribunal erred in law in quashing the charge sheet dated 31st of December 2008, failing to appreciate the Rule 58 Sub-Rule 4 of the Bharat Sanchar Nigam Limited Conduct, Discipline and Appeal Rules 2006, any misconduct committed prior to the issuance of 2006 rules. In my matter, Your Lordship, the charge sheet.
We are not on that.
Yes, sir.
We are saying that it is a matter of 2020. You
Yes.
have never obtained any interim order.
Lordship, it was not moved. It was once Your Lordship appeared before the Honorable Court and somebody, Your Lordship.
Then why should we grant you an interim protection?
Lordship, Your Lordship, I have Your Lordship, Central Administrative Tribunal, Your Lordship, is passing orders in a contempt. Now, Your Lordship, it was not moved. I understand, Your Lordship, the order is there, where Your Lordship, somebody appeared and prayed for Your Lordship adjournment. Today, I am before Your Lordship, only Your Lordship, kindly consider this my prayer.
When is the contempt fixed?
Contempt is fixed on 15th. Your Lordship, the next date is fixed on 15th of December.
Serve another notice and come.
In the meantime, if Your Lordship kindly protect me.
Will be there on 14th. You have kept the person in pangs from 2020.
I have cleared
You sleep over the matter.
Lordship, identical matter. I have cleared his PF. I have cleared Your Lordship some
It is
due.
not an identical matter. It is of 2023. You have taken thrice adjournment in this matter. See the order sheets.
I've seen Your Lordship.
Evidence of service filed by the petitioners be kept on record. Stop. No one appears on behalf of the. What is the name of the respondent?
Maniklal Kaur.
Maniklal Kaur. Where is his address now? Your address is under control of divisional English.
No.
You're addressed in the writ petition.
No. Now Your Lordship, he has retired. Your Lordship.
So where are you serving him? If he has retired,
197 Andul Road, Your Lordship.
how we are to know that?
Lordship, the petition, Your Lordship, is shows Your Lordship. Main cost title to it nahi, to Andul Road, na. At that point of time, Your Lordship, he was working. That's why, Your Lordship, the address is there. But Andul Road, we are serving, Your Lordship, this. And it has been received also. And it has been received, Your Lordship, if Your Lordship kindly sees the affidavit of service.
Evidence service filed by the petitioners be kept on record. Stop. In spite of service, no one appears today on behalf of the respondent number 1. Learned advocate appearing for the petitioner submits that a contempt application has already been preferred by the respondent number before the learned tribunal, and the same is fixed for hearing on 15th of
December
2020, and prays for issuance of an interim. Stop. To give a further opportunity to the respondent number 1 to appear and contest, the matter stands adjourned. Establish the matter for further consideration in the daily supplementary list of this court on when it is contempt is on 15th.
15th, Your Lordship.
On 14th. On 14th, the petitioners are directed to intimate this order immediately to the respondent number 1 and to file a fresh affidavit of service.
Your lordship pleases, your lordship can indicate, your lordship, if he does not appear, the matter will be taken up ex parte so that your lordship they will come. Or your lordship, may I serve it, your lordship, the person who is appearing in contempt before the Central Administrative Tribunal.
Sir,
Yes, your lordship. So, उनके serve करो.
the petitioners were directed to intimate this order, intimate this order to the respondent number 1 and also to the learned advocate appearing for the said respondent, appearing for the said respondent in the contempt application.
I'm grateful, your lordship.
And to file an affidavit. Yes, next.
Lordship, I am for the petition, Your Lordship. Your Lordship, on the last occasion, Your Lordship directed Your Lordship to supply a supplementary affidavit. So, Your Lordship, I have ready with the supplementary affidavit, Your Lordship. However, Your Lordship, the petitioner, Your Lordship, due to his her health condition, Your Lordship, she couldn't come. So,
This week, yes.
Please, Your Lordship.
The
Cardin Malad, I am for the petitioner led by Mr. Bari Malad.
Where is Mr. Mukherjee?
Last occasion, your lordship directed Mr. Mukherjee to take instruction.
Was with Justice Velumoni?
Yes, my lord.
Not this week.
Might be this, Your Lordship. But after the petition, but but the copy of this, I'm sorry.
Is the matter?
This matter, my lord, pertains to, my lord, of an employee, my lord. The affidavit of service is already there on your lordship's record. Earlier occasion, this matter was taken. So, my lord, the petitioner before your lordship, my lord, is the suspended railway employee, my lord, who prayed for increase of the subsistence allowance to the tune of, my lord, 50% more of what he was getting as per the rule itself. That was denied. And thereafter, my lord, he approached before the learned tribunal, and tribunal denied my claim, and then I am before your lordships.
This is final hearing, Mr. Roy.
My lord, I tell your lordship here because it is about my subsistence allowance, lordship. Only if because I'll be only relying upon your lordship some admitted position, nothing new. My lord, here your lordship will see the order impugned before my lord is the order of the learned tribunal, which basically, my lord, takes into account of a rule which says that a subsistence allowance shall be increased to 50% if there is no fault.
Where is your
I'm
service?
Sorry. My lord, it is there in your lordship's record.
We have asked you to serve afresh. Into the account.
They have received by hand, my lord, on 25th of September.
Eastern Railway, who appears?
But they have, my lord, received by hand, my lord. I'll just check it out and thereafter come back to your lordship. My lord.
Yes. When can you come back, tell us?
My lord,
because you come after the vacation.
My lord, it is my subsistence allowance, my lord. My lord, I will just ascertain who has been engaged.
Not this week.
My lord, let it be, my lord, tomorrow subject to your lordship convenience, because I'll just apprise your lordship who is engaged.
No, not this week.
As your lordship please.
Comply with the direction and.
I'll do that, man. I'll do that. Grateful, madam.
Yes, next.
My lord, I am for the petition, my lord. On the last occasion, my lord, your lordship was pleased to, my lord, indicate, my lord, whether, my lord, in the list published, my lord, the names of the petitioners, my lord, featured.
My brother was not there.
My
You tell the facts first. What is the matter about?
My lord. My lord, examination, my lord, was conducted, my lord, for recruitment of CITS, my lord, instructors. My lord, government ITI instructors. My lord, according to us, my lord, the mandatory criteria is, my lord, a CITS apprenticeship certificate.
Yeah, just a moment. Who are the who is appearing
My
for?
learned friend, my lord, is for the
You are for the
Public Service Commission.
Public Service Commission. And who are these pro forma respondents?
my lord, they are the petitioners in the tribunal, my lord, before the tribunal. My lord, they could not come up, my lord, because they stays in, my lord, in different parts of the, my lord, state. My lord, out of
You were also one of the applicants.
Yes. My lord, in tribunal, total 80 applicants appeared before the tribunal. Out of the 80 applicants, my lord, since, my lord, it was, my lord, the necessity of this filing this application, my lord, was because, my lord, the result was being published, my lord, on 24th. Therefore, my lord, only 8 of those applicants could reach before this Honorable High Court. My lord, I have made the others a pro forma respondent since, my lord, their name, my lord, is featuring in the
24th of
24th of, my lord, November.
Achha, tell us, you challenged the selection process.
Selection process, my lord.
You participated.
My lord, I participated.
And thereafter challenged.
And thereafter challenged, my lord? No, my lord. After the advertisement was made, I challenged initially, my lord, because according to me, there should have been a mandatory criteria of CITS qualification. Now, my lord, the advertisement was published without making the CITS criteria, my lord, without
making CITS?
My craft instructor, my lord, craft instructor training, my lord.
Craft instructor training.
My lord. Your lordship will, my lord, kindly take some.
Let us understand.
My lord.
Craft industrial training was not there. That is why you challenged.
I challenge. My lord, the applicants before the learned tribunal, they have it. They have the training.
Then what was the problem?
In the advertisement, it was not made a mandatory qualification.
It was desirable.
It was desirable, but not made mandatory. According to me, my lord, there should have been a preference, my lord, given to the applicants who, my lord, have the training.
I see. Very good. Then what did the tribunal say?
Tribunal.
By that time you had participated.
My lord, no. Tribunal, my lord, initially refused to, my lord, pass a stay of the advertisement. My lord, an order was passed, my lord, that the outcome of the examination will follow the, my lord, the outcome of the application.
My lord, kindly, may I pray one indulgence? My lord, kindly see the order of your lordship in earlier occasion.
Yes, yes, my lord. I was, my lord, coming to that, my lord. My lord, page 93, your lordship will, my lord, find the first order passed by the learned tribunal.
That was the only ground of challenge.
That was the only ground. That was the only ground.
You have to give preference to us.
Preference to us. And that should be made a mandatory qualification, CIT.
Show us the advertisement first.
My lord.
Or show us the tribunal order.
My lord, tribunal order, your lordship will find it, page 93. Page 93, the 13th February 2020 order, my lord.
Yes.
মানে কোনোটা অর্ডার হয়নি। তোমাকে আমি তারপরে পাঠালাম না প্রিন্ট আউট নেওয়ার জন্য ছবি তুলে।
রেফারেন্স পেপারটা কমপ্লিট চলছে চলছে আঠাশ তারিখে কি হলো? আঠাশ তারিখে কি হলো?
কোনটা?
আঠাশ তারিখে কি হলো?
28 তারিখে ডিক্লেয়ার হয়েছে তো।
না না এই যে
ও ওটাই আবার সিঙ্গেল বেঞ্চ বসছে বলে ইয়ে হয়েছে। একজন হচ্ছে মার্চ মাসে ডেট দিয়েছে।
দেবী
এখনো ডিভিশন বেঞ্চ বসছে না তো।
Yes.
Well, after the 13th February order
What is your prayer now?
my lord, prayer was, my lord, this application was filed before 24th, my lord. It was taken up on 23, when, my lord, the result was about to be declared on 24th. Now, my lord, the result has already been declared. Your lordship on that day, my lord, inquired, my lord, from my learned friend, my lord, who is appearing for the PSC, my lord, that whether, my lord, the list of this applicants before your lordship, whether their name is featuring in that, my lord, list.
After next is interview.
Next is, my lord, practical examination is already going on.
Practical exam.
Examination is going
So
on.
those who, that first list is after the list of the first list that has been published on 24th, that is of the candidates
who appeared in the examination, the qualified candidates.
Qualified
candidates.
So you have not qualified.
My lord, the result, my lord, says so. My lord, there are numerous indiscrepancies in the result, my lord. I am already on, my lord, I have already, my lord, taken, my lord, instructed my lord, clients, my lord, to take steps regarding that, my lord. They have already filed RTI. The roll, only a cryptic result has been, my lord, published. No cutoff mark was initially published. Their individual scores have not been, my lord, made known to them. My lord, numerous indiscrepancies are there, my lord, relating to the result. Now, my lord, the practical examination is going on, my lord. On Saturday, my lord,
You
started.
have not even qualified for being called for physical efficiency.
The
So what
practical,
right-
the practical examination.
Then what right do you have, Mr. Man? Today, what you are asking from us? You
Lord.
have come here for expeditious disposal and to stay the selection process. That is your
My lord.
no.
My lord.
So your grievance is the tribunal is without members.
Yes, my lord. There are, my lord, the state took a point that the matter is to be heard by a division bench before the learned tribunal. And, my lord, on consent of the parties, it can be heard by a single bench. My lord, the state, my lord, refused that consent. My lord, we are, my lord, ready to be the matter to be taken up by a single bench. My lord, the state says no, the matter needs to be taken up by a division bench. So, my lord,
Mr. Banerjee, today the list has been published, which shows that you are not qualified for the next stage of the selection process.
my lord.
Then at this stage, how can we stay your? How can we
My lord, at
come
this
to
stage,
your
my lord, I candidly submit, my lord, my prayer, my lord. Whatever my prayer was on 23rd, after 24th, my lord, that prayer, my lord, it's difficult to entertain. But my lord, candidly submit.
So you withdraw the petition and go and take appropriate remedy.
My lord, may I, my lord, only submit, my lord, that the matter be, my lord, expeditiously, my lord, heard by the bench.
There is a procedure, Mr. Banerjee. You have to withdraw. You have to incorporate these facts and go to the tribunal. Thereafter, also, if the tribunal is not in a position to take up the matter due to non-availability of members, then come to us. At this stage, Mr. Banerjee, how can we help you? Because we could have understood that had you been selected and they were not calling you for the next stage of the selection process, we could have.
My lord.
So nothing remains in this matter. No?
Nothing, my lord. What was, my lord, on 23rd, something remained, my lord. After 24th, my lord, it's difficult to entertain, my lord, my first prayer. Only, my lord, my lord, my second prayer, if, my lord, that can be, my lord, granted by your lordship, that, my lord, matter is to be reverted back to the tribunal. The tribunal is in session of this matter, my lord.
So let the tribunal, you are saying that there are illegalities in the list which has been published.
Sir, numerous.
Take necessary steps to that effect. We understand the tribunal is not considering your prayer for final year.
For 2 years, my lord. Your lordship, my lord.
At this stage, how can we help you? Tell us.
Your lordship only takes up, lordship, last thing, my lordship, my lord, submit before you. Lordship only takes up page number 101 once. Your lordship passed an order directing the tribunal to expeditiously, my lord, dispose of my application at that point of time.
Mr. Banerjee,
By 2000, my lord, by December
today,
2020.
if we consider your prayer. Today we have to reject your prayer that there is nothing in this matter because ultimately your names have not come in the select list. So why do you want to suffer a negative order from us?
My lord, withdrawal, my lord, may I, my lord, only come back with the instruction of withdrawal. My lord, my lord, withdrawal, my lord, your lordship kindly, my lord, fathoms my lord, the scenario, my lord, withdrawal, my lord, my lord, without instruction of my client, my lord.
Where is the list? Where is the list has been published?
List is published. It's a long, my lord, 36-page list, my lord. Only the result, only, my lord, the names of the qualified candidates, my lord, is published in the list. List. Only the names of the qualified candidates, the results of the other candidates, my mark sheet.
You are not even qualified now. Forget about the benefit of the CITS, non-incorporation, etc., etc. Today you are not qualified. Today, if you are aggrieved, you have to challenge the next list that I am qualified, but you have not called me. Which you are saying there are discrepancies.
Discrepancies, yes.
So you should shift your attention to that list now. We cannot advise you, Mr. Banerjee.
That I have already, my lord, indicated, my lord, to my clients, my lord. My lord, already, my lord, RTI applications have been filed by them, my lord, to know their marks, my lord, numerous other.
So we will record today that the list has been published in which your names do not feature. As such, question of issuance of the order as prayed for does not arise.
Lordship, my lord.
When was the list published?
24th November, list was published for the second phase of examination. That is going on, that is on 9th, 10th and 11th.
Today is the last date, my lord, for that practical examination. It commenced on Saturday, Sunday, and my lord, today.
My lord, may I submit one thing? Petitioner applied for the general post, my lord. Petitioner got 20 marks, and for the general post, the cutoff marks is 52.33%.
They are not disputing that.
Nowhere petitioner got his the chance, because petitioner's marks is too low, my lord.
My lord, the difficulty is I do not even know my marks. Right now, my lord, I am hearing, my lord, I have got 20. I do not even know. There are 8 petitioners, my lord. None of them know their marks.
This list you have published after what?
My lord, this list was published on 24th November 2023.
After screening their application.
After screening their application.
And they did not come, they did not secure above the cutoff.
Yes, lord.
Within the zone of consideration.
To come within the zone of consideration.
মরার উপর খাড়ার গাছ। He has already died. You want to further kill him. The present writ petition has been
He
preferred.
does not have the qualifications according to the recruitment rules.
The present writ petition has been preferred, inter alia praying for an interim order to stay the declaration of results of the examination held in terms of advertisement number 5 of 2020, notified by the Public Service Commission. For recruitment to the post of instructors in different trades at government industrial training institutes. Mr. Banerjee, learned advocate, appearing for the petitioners, submits that unless the interim order as paid for denied, the petitioners would suffer extreme prejudice. More so when the learned tribunal is not also, more so when the learned tribunal is not also in a position to hear the original application finally, in spite of a direction to this effect, to that effect, passed by a, in spite of a direction to that effect issued by a coordinate bench of this court in a writ petition being WP number WPST numbers passed in spite of a direction in WPST number 72 of 2021 on 15th of September 2020. Stop. Records reveal that challenging inter alia the selection process for appointment to the post of instructors, posts of instructor in various government industrial training institutes. The petitioner, along with the pro forma respondents hearing, preferred an original application being OA number
60 of 2020.
60 of 2020, in which an interim order was passed to that effect, to the effect that, quote unquote, in which it was inter alia observed that there shall be observed that in which an order was passed on 13th February 2020, observing inter alia that, quote unquote, no interim order is passed save and except the action taken by the authority shall abide by the result of the application, unquote, single inverted comma, item. Stop. Challenging such refusal, challenging the said order, the petitioners approach this court by filing a writ petition being WPST number 72 of 2021, which was disposed of by an order dated 15 September 2021. Refusing the petitioner's prayer to restrain the respondents from publishing the result and from filling up the posts. Refusing the petitioner's prayer for interim order to restrain the respondents. Miss Sarkar learned advocate appearing for Public Service Commission submits that after scrutiny of the applications scrutiny of the applications of the candidates who participated in the selection process, comma, a list has already been published on
24th November 2020.
24th November 2023. Stop. The petitioners here did not secure the cutoff marks, and as such their names have not been included in the list which has been published. Stop. Stop. In view thereof, in view of the earlier order dated 15 September 2021 passed in the writ petition being WPST 72 of 21, and as the petitioners have not secured the cutoff marks and as they have not been included in the list from which the candidates would now be called for
Interview.
Physical test part 2. No, interview naki. Physical test.
physical test.
Physical test.
Physical test.
It is called physical test.
Yes.
Physical test.
Physical test part 1.
Physical test.
Physical test part 1 or part 2?
Part 2.
If you are not sure, then don't tell us because we are recording it.
Whatever information I get, my lord, the information from the authority, it was practical test.
My lord, screening, my lord, I'll just indicate.
First screening test, then
It is all
practical
right.
test, then interview.
Or let us and as the
And as
petition
the petitioners have not secured the
cutoff marks, comma, question of grant cutoff marks, we are we refuse declare as the petitioners have
PST.
not secured the cutoff marks.
Practical.
PST 2, Roman 2.
PST 2.
The petitioner's prayer for fresh interim order in this application is refused. Refused. Stop. Is refused. Is refused, and the writ petition being WP number such and such is dismissed. There shall, however, be no order as to cause.
Yes, for Chakraborty. Yes.
I appear for the petition.
My lord, I am led by Mr. D.N. Rai, my lord.
My lord,
Matter
in
for
this
union
matter,
petition.
the subject matter of the present petition is really May I please, Your Lordship?
The final hearing.
Yes, my lord. On the other day, my lord, Your Lordship was pleased to, my lord,
Judgment, my
hear
lord,
at
2000
length
my lord,
and to
2013
excellent, excellent, bhai.
NCC.
My brother was not there. My brother
I'm
was
telling you,
not-
Lordship, very short facts of the case.
Let us see.
My lord,
Please tell us from the beginning.
Yes, my lord. I was the assistant driver in the railway. I was
Assistant
driver in the railway driver, assistant driver. My lord, a selection was initiated for promotion to the post of next higher post, that is loco pilot diesel. My lord, I was eligible. I was called to appear in the selection. I appeared in the selection. My lord, I qualified in the selection. A select list was prepared. My serial in the select list was 73. But when the promotion was given, I see that my junior much below was given promotion, excluding me. Then I challenged before the learned tribunal. In the learned
It was a promotional process.
promotional process.
You participated in the
Yes,
LDC,
Yes.
limited departmental examination.
Yes.
Then you
Now,
succeeded.
departmental promotional committee before the learned tribunal, when
No, you succeeded.
yes,
Then what happened? You were
my lord,
given promotion.
promotion was given to my junior. I was not given promotion.
Oh, junior was given, you were not.
I was
Why?
not.
Why?
I'm telling you, Lordship.
Hmm.
That was challenged by me. My lord, before the learned tribunal, they said that the departmental promotional committee had not, as per his ACRs, recommended his case. So that that was the first round of litigation. So the learned tribunal what did, directed the authority to supply me the annual confidential reports for last 5 years and directed me to give written representation against that. The DPC will consider the same and pass appropriate order. Now, in terms of that order, DPC passed order, my lord, affirming or confirming their own stand, which was also challenged.
Confirming their
Earlier stand.
what was their earlier?
Earlier stand that I did not. I'm telling you, what was the earlier stand that I could not secure the marks because of the my lord, uncommunicated adverse remarks. Uncommunicated adverse remarks, I could not secure the mark. That is the position, and that was also ultimately, my lord, confirmed. That was the order dated 15th of March 2010. I'm telling you, Your Lordship now need not go. I'll place Your Lordship. That was also challenged in the second round of litigation. In the second round of litigation before the tribunal directed, after considering all pros and cons, to consider my case and to pass order of promotion to me. From the date, my junior was given promotion with all consequential benefits. So, my lord, I believe this is my submission that after this order was passed, the last part may not be so vividly looked into. May not be. I will place. Still, I will place. If you lordship kindly turn to that order, which starts from page 50 of the petition. Page 50 of the petition. That was order passed by the learned tribunal in my second original application. Page 50.
Can you read this?
My lord, if you lordship kindly turn to page 55. If you lordship kindly turn to page 55.
We cannot read this order, Mr. Sen. You can read this.
My lord, if you lordship kindly turn to page 55. Kindly. The operative part of the order. Operative part of the order.
How can we read? Give typed copies of this order.
Well, kindly, my lord, I will give my lord. If you lordship kindly turn to page, because I want
Your
to.
junior knew that this is in such a state, and so many days wasted. You could not prepare a typed copy.
This is my fault.
How can my brother read? My copy is still there. My brother's copy is totally empty.
May I beseech your lordship kindly turn to page 55. Kindly, for a moment. For a moment. What is the order ultimately passed? Kindly, 55. It is legible and readable. I may place it for your lordships. Considering the facts of the case and on perusal of the records, we are prima facie satisfied that the impugned rejection order dated 15th March 2010 does not sustain and the same is liable to be quashed. Accordingly, it is quashed. The respondents are directed to constitute selection committee and consider the case of the applicant for promotion to the next higher grade from the date his junior was given promotion with all consequential benefits. Well, I put a stress, my lord, on the word with all consequential benefits. That order was not challenged. They complied with that order. They passed order thereafter. If you lordship kindly turn to the next page 55. What is the order they passed in compliance
That
of
is the 15th March 2010 order.
15.3, my lord, is at page 47, 46 to 47. Page 46 to 47. That order was challenged in the second original application.
15th of March.
Yes, 15th of March, page 46. Ultimately, finally, having gone through all those facts and aspects, I have come to the conclusion that your gradation as average in the years of 2001 to 2002, 3, 2003, 4 stands justified basing on your overall performance. Even you may have considered it other way out of your misconception, and the same will stand good without upgrading or degrading or expunging them. This disposes of the representation.
Yes.
My lord, this was challenged in the second round of litigation, in which the order, my lord, I have placed now, was passed. Right? After this order was passed, they have not challenged whether they complied with that order. By passing an order which is at page 56. Next page, page 56. In obedience, may I place it, my lord? In obedience of the Honorable Calcutta Bench order dated 26/6/2012, passed in OA number so and so, Senior Diesel Assistant Loco SRC, revised designation Senior Assistant Loco Pilot in the scale of so and so, presently working as Loco Pilot Goods under SSC Loco KGP, is hereby promoted to the post of Loco Pilot Goods grade 2 in the scale of so and so in PB2 plus grade pay 4,200 on pro forma basis from the date of promotion of his next junior C.M. Paparao. My lord, Paparao,
Effect from
with effect from 28/7/2004. 28/7/2004. That is from the date of taking over charge of the said post by C. Rao to 8/9/2010. So, my lord, the pro forma benefit promotion was given for the period 27/2004 to 8/9/2010. Now, from the next date, when I took over the charge, that is 9th of September 2010, actual promotion was given, awarding me the actual benefits. This very order was challenged in the last litigation, out of which the present petition has been.
Again challenged.
What can be done? Because my period, that is the pro forma promotion period,
So
actual benefit was not given.
You were not.
Actual benefit for the pro forma promotion period was not given. Although by the order in the second OA, direction was given to give promotion with effect from the date, from the date my junior is going promotion, with all consequential benefits, which includes the actual benefit from the date of my junior was given promotion.
But you did not work in that post during that period.
My lord?
You did not actually render service during.
Yes, yes. I'm coming to that. But after this order was passed with all consequential benefits.
Now you have retired.
Retired. Voluntary retirement. My lord, I'm telling your lordship.
Now you want that, give me that benefit.
Benefit
actual
for the
benefit
for the
during
pro
that-
forma period, pro forma promotion period.
Mr. Sen, you did not work during that period.
My lord,
So they
my
have
lord,
given
for
a-
that,
for
for that,
they have given a consequential benefit.
all consequential benefits.
Right.
Now, my lord, I have relied upon before the tribunal a judgment of 2000, Honorable Supreme Court rendered in 2007.
All right, let us come to the tribunal's order.
Yes. On the same line as it fell from your lordship that I did not know work, no pay principle, because I did not, number one. Number two, 2007 judgment of Honorable Supreme Court, which says that the authority in such a case will ignore the laws, judgments, etc. They have to give benefits.
Also, show us what did the tribunal say?
Yes. Kindly, my lord, your lordship may kindly turn to inner page 6 of the judgment.
Yes.
Inner page 6 of the judgment. The view of the. May I please sit, my lord? We have gone through the complete judgment cited by learned counsel for the applicant.
Where you are reading, Mr. Sen?
Paragraph 6.3, inner page 6 of the judgment. Inner page 6 of the judgment.
Yes.
Paragraph 6.3. We have gone through the complete judgment cited by learned counsel for the applicant. Honorable Supreme Court, referring to its judgment in an earlier case, observed that the respondent government had passed a law to deny payment of back wages. To deny payment of back wages in case of promotion with retrospective effect. This act of the respondent was deprecated by the Honorable Supreme Court, which declared this law as ultra vires and directed payment of back wages as ordered by the Honorable High Court. Honorable Supreme Court, while passing the aforesaid judgment, also observed that principle of justice and equity demanded that if the mistake in denying promotion to the applicant in his turn has been committed by the administration, and if the petitioner is in no way responsible for the delay, he should be treated as if he held the post from the date he has been subsequently promoted, and he should be paid with arrears of wages for the past period. I will place your lordship the judgment. It is obvious from the above that in C. Muddaya, the Honorable Supreme Court had specifically directed that back wages be paid to the petitioner regardless of the provisions in the relevant act passed by the Karnataka government. In the instant case, the tribunal had directed payment of consequential benefit without saying that all consequential benefit. I say that all consequential benefit. Without specifically directing that consequential benefits included payment of arrears for the period he did not perform duties. Here I, my lord, pause, my lord. Since, my lord, by the order of passed in the second round of litigation, direction was given to pay all consequential benefits. Does it lie? This particular observation, I am again placing. In the instant case, the tribunal had directed payment of consequential benefits without specifically directing that consequential benefits included payment of arrears for the period he did not perform duties in the promotional post. In the absence of any such specific directive, the respondent have interpreted consequential benefit as benefit of seniority, higher pension, etc. As per the rules of in vogue, payment of arrears of pay for the period during which the employee has not held the promotional post is not treated as a consequential benefit as a promotion affected from a retrospective date. This is, my lord, quite, my lord, in disregard to the judgment and observation, a specific direction given by the Honorable Supreme Court in the 2007 judgment.
Please show us the Supreme Court judgment.
Judgment.
Now read the next paragraph, Mr.
I'm pressing. I'm just pressing. I'm just pressing. Next paragraph. 64. Judgment. 6.4. It is obvious from the above that in C. Muddaya Supra, the Honorable Supreme Court had specifically directed the back wages be paid to the petitioner, regardless of the provisions in the that I placed 6.4. Now, 6.6. 6.6. We have also gone through the judgment of Tarsemlal, that is of 2006. In this judgment, Honorable Supreme Court has specifically upheld the policy of the railways, which provides for non-payment of arrears in case of promotion with retrospective effect. This policy has been relied upon by the respondents in denying the arrears claimed by the applicant. Honorable Supreme Court in Tarsemlal case has referred to its own findings in Union of India versus P. Abraham in CA number so-and-so, and in Virender Kumar versus Avinash Chandra Chando, reported in 1993 SCC 3 SCC 2472, where the following clause in para 228 of IRM, which was struck down by CAT and Mercolam, was upheld by the Honorable Supreme Court. Clause, what the clause reads: the enhanced pay may be allowed from the date of actual promotion. No arrears on these accounts shall be payable, as he did not actually shoulder the duties and responsibility of the higher post, as it fell from your lordship. Now, thus the Honorable Supreme Court has specifically upheld the validity of the above provision in the IRM, whereas in C. Muddaya, Honorable Supreme Court dealt with the case relating to the state of Karnataka. In the instant case, the applicant is a railway employee governed by the provisions of IRM, which have been validated by the Honorable Supreme Court. Here, my lord, may I submit one thing? I'm pausing here for a moment. My lord, in following a judgment or in relying upon a judgment of the Honorable Supreme Court or higher forum, my lord, the ratio of the principle of law laid down is to be followed. It is binding. Am I clear to you? Then, what in a judgment say upholding the particular IRM provision is not ratio. But in 2007 judgment, ratio was placed. It is specifically said that when the judgment was not challenged and you have passed order in compliance thereof, you have to comply with in toto. Otherwise, rule of justice will be washed away. Very fine judgment was delivered in the 2007 judgment. I'll place it, Lordship. So, my lord, normally, my lord, the judicial discipline says that subject to Lordship's correction, the later judgment will prevail in the same field. The field of law is whether back wages for promotion from retrospective effect should be given or not. When that is the law. Now, 2007 judgment laid down. No, you have to give it, regardless of what is there in the your provisions or rules or law. I'll place it, paragraph 32 of the judgment. So, my lord, number one, it is a later judgment.
Which one is a later judgment?
My Muddaya case, 2007 judgment. And they relied upon 2006 judgment. They have, it is also on record. It is in their reply to it is there in the record. 2006 judgment.
This is Muddaya was
Muddaya was relied upon by us.
That is of 2005.
7.
2007.
Delivered, you will also kindly see, delivered on
7th of September 2007.
Yes.
Tarsemlal is much earlier.
2006. That Tarsemlal regarding limitation, continuation of the cause of action. That is another case. That is another case. That Tarsemlal is another case. My lord, first one, as I have already placed before lordship, that the later judgment will prevail.
Mr. Sen, you have also been given seniority. In fact,
but
seniority also does not come within consequential relief. Latest Supreme Court says that when you are granting back wages, seniority, when the person is reinstated from the date of removal, then court says that, giving all
that is in a case of removal, man.
Pardon?
That is in a case of removal.
That is in a case
of removal from service, reinstated.
Supreme Court now says consequential benefits does not include seniority. But you have been given the seniority. You must be satisfied, Mr. Sen.
No, my lord, by arrears payment, my lord, I should not say to your lordship, no, my lord, it is my lord, can you pardon me in saying, placing my submission in that way. I should not
Mr.
say
Sen,
no to my lords.
No, how can we, because the ratio of the tribunal is that in Tarshemali, the IRDM was taken into consideration, upheld up to the Supreme Court. But in the case of Muthaiya, it was a case of state of Karnataka, service conditions were different. But your argument,
same point. Point is same.
Argument is the proposition of law according to you is once you are given a belated benefit, suppose you were
not
wrong,
for my fault.
Wrong.
Not for my fault. It is their fault that they did not allow me to work.
Exactly. For that, they cannot recover anything from it.
This is the provision.
Branch.
This is the provision of railway laws, IRM provision. But what the Supreme Court had said in 2007 judgment, I will place before your lordship. Kindly, my lord, take the paragraph 32 of that judgment, 2007 judgment. Kindly.
Muthaiya.
Yes. 32. May I place it for your lordship?
Yeah, just a moment.
জানি না এখানে বসে আছে টাকাটাই করছে না ফোন করে জিজ্ঞেস কর দেখ আমাকে দেখ তুই এখানে বসে আছিস তুই ওখানে যা না বারবার বলছি যাও ওখানে ওর জন্য এখানে বার কারণ
Yes, Miss. 32.
Yes. The matter can be looked at from another angle also. I will place 31 later. It is true that while granting a relief in favor of a party, the court must consider the relevant provisions of law and issue appropriate direction keeping in view of such provisions. There may be, however, be cases where, on the facts and in the circumstances, the court may issue necessary directions in the larger interest of justice, keeping in view the principle of justice, equity, and good conscience. Take a case where expressly injustice has been meted out to an employee. In spite of the fact that he is entitled to certain benefits, they had not been given to him. His representation had been illegally and unjustifiably turned down. He finally approaches the court of law. The court is convinced that the gross injustice has been done to him and he was wrongly, unfairly, and with oblique motive deprived of those benefits. The court, in the circumstances, directs the authority to extend all benefits which he would have obtained had he not been illegally deprived of them. Is it open to the authorities in such a case to urge that as he has not worked but held to be illegally deprived, he would not be granted the benefits? Upholding of such a plea would amount to allowing a party to take undue advantage of his own wrong. It would perpetrate injustice rather than doing justice to the person wronged. We are conscious and mindful that even in absence of statutory provision, normal rule is no work, no pay. Mindful. In appropriate cases, however, a court of law must take into account all the facts in their entirety and pass an appropriate order in consonance with the law. The court in a given case may hold that a person was willing to work but was illegally and unlawfully not allowed to do so. The court may, in the circumstances, direct the authorities to grant him all benefits considering as if he had worked. It therefore cannot be contended as an absolute proposition of law that no direction of payment of consequential benefits can be granted by a court of law. And if such directions are issued by a court, the authority can ignore them even. Authority can ignore them even if they had been finally confirmed by the apex court, even if they have been finally confirmed by the apex court of the country, as has been done in present case. The well contention of the appellant board therefore has no substance and must be rejected. What a ratio has been laid down. Court was mindful to the no work, no pay principle. But still thereafter, court say, not mandatorily, but may, in a given case. That is very important, my lord.
Yes.
And it has been categorically stated and laid down that in such a case, they will ignore the provisions of law, even the judgment of the apex court in such a case. If it is in an appropriate case, it is found that he has been unjustifiably denied the benefits. Therefore, after paragraph 32, it has not been, my lord, properly, my lord, considered by the learned tribunal. Number one. Number two, if you lordship kindly turn to page 31 of this judgment. Now, paragraph 31 of the judgment.
Yes.
May I please? We are of the considered opinion that once a direction is issued by a competent court, it has to be obeyed and implemented without any reservation. If an order passed by a court of law is not complied with or is ignored, there will be an end of rule of law. If a party against whom such order is made has grievance, the only remedy available to him is to challenge the order by taking appropriate proceeding known to law. But it cannot be made ineffective by not complying with the directions on a specious plea that no such direction could have been issued by the court. In our judgment, upholding of such argument would result in chaos and confusion and would seriously affect and impair administration of justice. This argument. But after these two paragraphs, nothing remains. Number two, my lord, even I assume that these in two judgment, one of Tarsemlal of 2006 and this Muddaya of 2007. No doubt, those are in the same field of law.
No, not in the same field.
Same field, madam.
That was guided by the service condition of railways.
But what is the subject matter of the railways law and Karnataka government law? Subject matter is related to, my lord, giving retrospective promotion with actual benefits. That is the case, subject matter.
Yes.
Regardless, the law is of which state or which concern, whether it is of railway, whether it is of a particular state or not, that is not looked into. Law what? Subject matter of the law what is that? Now, in such a case that two contradictory judgment, if I may say so, in the same field governs, then what the High Court will do?
No, this is not contradictory judgment because that judgment was delivered taking into consideration the service conditions involved in the same.
Subsequently, court said, they will have to
understand your contention, Mr. Sen. Your contention is that irrespective of the service conditions, what is the proposition of law? Proposition of law is if you have been illegally denied of the benefits, you must be given the entire back wages. We are understanding.
Right. Grateful to you.
Yes.
Grateful.
What is your next point, Mr. Sen?
Well, in a
These are,
if it is a case that two judgments of the Honorable Supreme Court are contradictory, then our special bench, headed by Honorable Justice A.M. Bhattacharya, sitting with my Lord Justice Mitra and Justice Nayak, say that in such a case, the High Court will consider, will be at liberty, according to judicial discipline, will take
Judgment to be followed.
which judgment to be followed. Say
Later
that,
judgment.
later judgment, and which is more reasonable. I have also brought this judgment. I'll be giving this.
Where is your senior?
My lord is engaged in court number 35, my lord. And my lord, we relied upon whose judgment, my lord?
Let him finish. Ask him to come.
This is, my lord, page 1, AIR 1988 Calcutta Special Bench Judgment. That is, although it's not required, but because it is special bench judgment, say that the which one to be relied upon if two judgments are prima facie or on the face of it that are contradictory in a particular field of law. Later judgment will be followed, that is the discipline, judicial discipline. In addition to that, say the court will follow the judgment which is more reasonable in principle.
Paragraph.
My lord.
Yeah.
Paragraph. My lord, paragraph 13, 14. The latter review appears to us in a perfect consonance with that of our ancient jurist, Narada declared Dharma Shastra Virod to Yuktikota Vide Smriti. That is, when the Dharma Shastras or law courts of equal authority conflict with one another, the one appear to be reasonable or more reasonable is to be preferred and followed.
Yes.
In addition, that later judgment is followed. In addition, this.
Mr. Sen, have you brought Tarshemali?
Tarshemali, my lord, it has been on record, my lord, in the petition I'm placing. Tarshemali,
sorry, Tarshem Lal.
Tarshem Lal, Tarshemali regarding delay, continuing cause of action.
Continuing cause of action.
Now, Tarshem Lal, Tarshem Lal is, my lord, page 74. Page 74. They annexed to their reply. Filed before the page 74. Page 74. Half page is, my lord. This is also a defect on my part. Half page sheet. Half sheet, it is also a defect on my part. This is on no work, no pay principle. Oh, Dr. Ajit Pasat. You know, একা বসে হতে পারে না।
Yes. Tarshemali, yes.
This is Tarsem Lal.
Administrative error.
Last page, that is page 75. This court, in that case, held on principle of no work, no pay. Last page, no work, no pay principal basis. Very well-known principle, no work, no pay. But did, sorry.
Where you can dismiss the application of he is bound by these articles. So consequential remedies have to be read inside the but you have the equity.
Well, this was on the basis of the principle of no work, no pay. But the court in that case in Tarsimlal did not consider that.
No work, no pay did not consider.
Yes, last page of the judgment. This court in that case held on principle in the earlier case, referring to the earlier case. Page 75, left-hand side.
Page 75?
Yes. It starts from page 74 at 75. From top, first, second, third, fourth, fifth, sixth, seventh, eighth, ninth, 10th line.
This court in that
case held on principle of no work, no pay, that the respondents will not be entitled to the higher salary as they have not actually worked in that post. But did not consider, on the contrary, if I may say so, subject to your lordships, that in other eventuality, if I was not allowed to work for the fault of the employer, not for my fault, what will happen? That has been considered in the latter case. And said that actual benefit has to be given, giving or considering that he was as if he was in the post and discharge duties from the date, from the retrospective date. Specifically said. Therefore, principally, or in regard of principle of law laid down, well, better principle laid down in 2007 Muddaya case. Why better? Because only considered in Tarsimlal, no work, no pay principle. But did not consider in the eventuality where the employer is at fault, not the employee, and he was prevented from discharging his duties. What is his fault?
Yes.
So, my lord, these are the two judgments I am relying, my lord. Therefore, I am entitled to the actual monetary benefits for the pro forma promotion period, that is the period
4 to 2008.
Yes, from 28 July 2004 to 8/9/2010.
Yes.
And the judgment of the land
judgment, my lord. One is, my lord, 2013 10 SCC 324, my lord. And my lord, one is 2022 SCC online SC 499. This is also reportable judgment, my lord. No. 2013 10 SCC, my lord. Whether, my lord, without holding the post and discharging duty with whether actual salary can be claimed, my lord. This is the judgment, my lord.
2013 10 SCC
10 SCC 10 SCC 324. And my lord, another, my lord, 2022 SCC online SC 499. This is SCC online, my lord. This is reportable judgment, my lord. My lord, hard copy, my lord. I'm sorry, my lord. Hard copy with not with.
Second
2022 SCC online SC 499.
SCC online SC.
What is your argument on this?
My lord,
where is Mr. Roy?
Mr. Rai is engaged in court room 35. Matter is running, my lord. He told me to judgment.
This is not, that is a disciplinary proceeding.
And
back wages in connection with a disciplinary proceeding.
Another is, my lord, 2022.
SCC online, huh?
SCC on.
Page 499.
499.
কালকে দুটোর সময় কিছু ফিক্স আছে?
May I show you, my lord? Mobile phone, my lord. 10.
ওখানে আছে তো, তুমি বলো না
2022 13 SCC. Yes, my lord.
Do you know the facts of the case?
No, my lord.
No, my lord. That is why we are asking your senior to come.
Then, my lord,
We are not concerned. He has placed the relevant law on the subject.
yes, my lord. Then, my lord, fix
We are
it, my lord.
keeping it tomorrow at 2 p.m. fixed.
Yes, my lord.
Either
Tomorrow, my
Mr. Roy appears or we pass our order.
Yeah, my lord. Tomorrow, my lord. Kindly
Mr.
fix it, my
Sen, learned advocate appearing for the petitioner has concluded his arguments. Is the matter as for orders?
Grateful.
The daily as for orders on Kalke dated as fixed at 2 p.m.
I am grateful to you, Lord.
ওটা একটা লিখে দাও। Mr. Sen, learned advocate appearing for the petitioner has concluded his argument. Next para. Mr. Royal, however, an adjournment has been prayed for on behalf of Mr. Roy, learned advocate appearing for the response. In view thereof, is the matter as for orders on as fixed at 2 p.m.
Grateful. Very good.
I am appealing for the petition.
For 18, my lord, I am praying for not today, my lord. Respondent, my lord.
Why?
My lord, Mr. Rai.
Come tomorrow, Mr. Neo.
In this matter, Mr. Rai prayed for accommodation for his instruction from the department. My lord, in this matter, in the morning, I prayed for leave of this court to file. The petitioner is living in Siliguri, my lord. His mother is seriously ill and in hospital. He is a 66 years old retired railway employee. He settled at Siliguri. What I am prayed for, my lord, an affirmation before, and I have put out an application in this matter.
What have you included in your application? Any circular?
No, my lord.
Then
nothing.
what?
Then, my lord, in the prayer
What?
section, where
What is the document annexed to this application?
I have not annexed any documents, my lord. I have prayed for amendment of the writ petition.
Amendment of the writ petition?
Yes, ma'am.
Then, sir, let it appear after vacation. Let the person come and affirm, because a notarized public. Yes, we keep it after the vacation.
Yes.
Let his person be safe. Let him recover. In that, thereafter you come and mention. কি order করা আছে কিছু এটা? এটা কি ওই 9th of January রেখে 9th January it will come. That will be okay for you.
This is my petition, my lord. My lord, I would be asking for an adjournment in this matter.
I am appealing for Union of India.
Service is not complete, my lord.
You're for the petitioner?
Yes, my lord.
Any private respondent?
Yes, 39 private respondents.
Mr. Pan.
Well, I tried to serve on Mr. Ashok Sarkar, who was appearing before the learned tribunal. He refused. That's the whole problem. Otherwise, the matter could have been taken up today.
Also, Mr. Pandal and advocate appearing for the petitioners. Prays for an accommodation to complete service upon all the respondents. Who you are?
My lord, I am appealing for Union of India. Respondent number 39.
My lord, basically what has happened, my lord, the respondents have been directed to create supernumerary post and give regularization from a retrospective date. which is palpably wrong. This order is palpably wrong, my lord.
But who are you appearing?
I am appearing for ICAR, Indian Council for Agriculture, and he is appearing for the
Actually,
Union of
ICAR, my lord,
we are
doesn't have any kind of.
We are an autonomous body. We cannot create post, first of all, and the financial part would be taken up by the government of India. So,
So he is your friend.
he is my friend in this case, particularly in this matter. But otherwise, my lord, the financial implication would be on the government of India.
So why do you worry, sir?
I worry because I am not the person who can create supernumerary posts.
Direction was upon
Yes.
Yes, my lord, there is no specification, and my lord, relying on a judgment passed by the Honorable Supreme Court, stating that they belong to the similar category, my lord, without dealing with, my lord, the case record, my lord, without dealing with going into the merits of the case.
The Lordship seized the order, my lord, the last day.
earlier order also service not complete.
Yes. That's the whole problem. Let it be the first week of January, my lord. In the meantime, I shall come.
We have said it will appear motion central in the combined monthly list of December. How
Yes.
anybody mentioned for upgradation?
No, no.
No, it was taken up by your
It was
lordship.
taken up by your lordship. I said that on the last occasion that all the reply, rejoinder, everything is ready on the record.
এটা monthly list, next monthly list এ করে দিও ওই caption. Yes, complete service in the meantime.
My lord, I'm grateful.
Grateful, lord.
Number 20, my lord, I'm led by Mr. T.N. Rai, my lord. I'm appearing for the appellant, my lord. 20 and 21, my lord. I'm praying for not today, my lord.
Not this week. Yes.
My lord, this matter, in this matter, my lord, I am for the respondent, my lord. My lord, I am for the respondent. My lord,
the petitioner, so he's engaged in number 550 to kindly pass over.
Item number
22.
It was heard earlier.
I have been instructed. I'm not.
We will dismiss your matter then.
Maybe I'm not.
Mr. Chakraborty, you're appearing for whom?
For the respondent, my lord, the order was challenged, my lord, by the railway authority.
You are appearing in which matter? It's a কত নম্বর?
20 and 21, man.
That's already over.
20 and 21, what we have made it not this week. Somebody appeared and prayed for an adjournment.
My lord, not this week, my lord, just after vacation, whether it will be possible, my lord. Just after vacation.
Chakraborty, he has left.
My lord, I have nothing to say. My lord, yes. Next week, my lord, I will. Next week.
To renew your prayer, we will consider.
Right.
Not today. Yes, next.
Praying for Passover.
Not this week. Who is for the, you are for the?
Union of India. Lordship.
You are for the petitioner.
Petitioner.
Why you are not doing the matter?
Mr. Basu is appearing in court number 550.
Yes, 23.
Item number 23.
Lordship 23 and 24 are similar matter. Mr. Shomo Mujumdar is appearing item number 24. He is out of station. I'm praying for days accommodation.
Who is for the petitioner?
I'm for the appellant in item number 23, 24, Lordship. And 23.
It will come after vacation then.
After vacation.
After vacation করে দাও ওই 9th January করে no, these are all central motion head na returnable motion.
I know item number 23 both sides are present. Item number 22,
but that is to be heard along with 24 na
23 and 24
that's separate. 20 and 24 is I think related.
23 and 24 Lordship, are together. 23 and 24 are together.
Both sides are present. 22, kindly take it.
What are the applications there?
The application
You are appearing for whom?
Union of India. I am for the Union of India and other respondents.
You are in 22.
Yes.
22 is over. Somebody took time in that matter.
Passover, Lordship.
He is a
22
petitioner.
people.
He is a petitioner. I am the respondent. Present. Where
Who is petitioner?
he is a petitioner.
He is praying for an adjournment on ground of his senior.
Not adjournment is Passover, it's engaged.
He's taking the Passover. And Lordship passed the order adjournment.
Yes, because Passover we have not entertained. We cannot do so. Then
I have understood that both are sides are present. Why you are not taking the matter? Senior, he is a senior.
you understand what has happened. He came and he prayed for a Passover on behalf of his senior. We said that Passover cannot be granted, we have adjourned it. Do you have any problem with that?
Matter is that.
Don't question the court. How can the court do? Don't question the court.
Why not?
Sir,
You are questioning the court.
Yes, both sides are present. Why not take
Talk with your friend whether both sides are here. You suddenly entered the court.
Other day he has taken time.
So tell it properly, not in this manner. You are quite senior.
Yes.
Keep your heads on.
I told him. That I've understood. That I've understood. But every day he's taking time for the senior has not come. This is not fair. This is not a fair.
How do you train your junior? Why didn't you junior say so? Why didn't your junior say so?
Junior says so. Why should junior say so? I am present and junior is present.
Junior was present earlier to you. You were not there when the matter was called off.
At that time, I was engaged in another court.
Alright,
adjourn the matter, but it is not fair.
What is not fair to you?
Every day is time taking the time for the senior. It is not fair.
Every day means the last day also
Last
is
day
appeared.
also. Last day also.
When did you take time? Last day you took time. All right. ওটাকে password করো. After 2 p.m. we will take up the matter.
All right.
Ask your senior to come, otherwise we proceed. 2 p.m. we have a fixed matter now. 2 p.m. Then come tomorrow. Tomorrow. Mark করে রাখো তো।
Don't mind
Sentence is wrong.
No.
But you are an aged person.
Anything I am saying, everything is court. Don't mind losses.
Then why do you say so?
I am saying
You should do so because you have not uttered the proper language. Next matter.
Lordship, with regard to item number 23 and 24, it's...
Wait, let it be called on.
It was...
Yes, Dakur. You people are here to take only adjournment. And at the time of mentioning, you dance about. Fix it tomorrow, fix it tomorrow. When the matter is called, none of you are present. Yes. 23, who is appearing? You are for the...
I'm praying for short Passover. Mr. Esen
Short
Dotto,
Passover. Where is your senior?
he is engaged in court room number 550.
Who is your senior?
Esen Dotto, Mr. Esen Dotto.
Dekhi file ta dao. And who is your other side?
Lordship, in 23, we are for the respondent. In 24, Your Lordship, we are for the appellant.
You mentioned the matter before us.
We have not. It was taken up, Your Lordship, just after the reopening. Lordship directed to appear on 6th December along with our matter. No mentioning was done. No mentioning was done, Your Lordship. It was automatically came up because the matter was supposed to appear as per the form which we have filled up. So it has come out.
Not this week.
Lordship. And 24 also, Your Lordship.
এগুলো সব মেনশনিং স্লিপ করে
Deeply obliged.
Malady 19 number 25. Well, I am appearing on behalf of the Union of India.
Yes, Mr.
But the petitioner before your lordship offered his candidature for the post of constable in the Central Armed Police Forces. But your lordship knows 6 or 7 forces are there, 8 forces are there, and they are organized under the one umbrella. They organize the selection process. But so far as the selection process, your lordship knows the segregated in 2 parts. First of all, the physical ability and other parts. Ultimately, the final test is the test of medical examination. And while holding that medical examination, the authority detected some scratch mark on my left hand. And accordingly, after their decision or their the expertise, they said that no, I am not fit because I am psychiatric. Then, according to the statute or the norms prescribed in the selection process, I was sent for review. But the reviewing authority, also held like this. Now, your lordship kindly turn to the 2 pages of the decision.
No, where was the first medical report?
My lord, page 28.
No, this is review medical board.
On page 28, detailed medical examination at page 28. Your lordships kindly have it.
No, but this is of review medical examination.
But review is at page 30, my lord.
Then what is this page 20?
But page 28, at the first blush, but your lordship knows multiple cut marks on left hand.
That was the
initial finding.
Now it went to review.
Then they referred it to the review.
I see.
And my lord, your lordship will find. And my lord, page
29 is a part of page 28.
Yes.
Right. So what is this?
Hesitation cut marks. Hesitation cut marks.
What is
left
hesitation
hand.
cut marks?
Left hand, psychiatric
review.
Review.
Achha. Now review, what did they say?
Review said hesitating cut marks noted at the left forearm, psychiatric open noted
has tendency deliberate self-harm. Has tendency deliberate self-harm. My last occasion, your lordship was pleased to
and
ask my learned friend on 23rd of November 2023. Do you produce a order? Similar type of order has been passed. That was
Mr. Roy was not.
Mr. Roy was not.
Mr. Roy was not. But one thing, if your lordship kindly.
Now what happened, Mr. Roy? Thereafter, what happened?
Thereafter, we approached the local the district hospital where I reside. They organized a board.
Who was that?
Page 39 is the. Your lordship kindly see.
Page 39.
They are the different experts who held the board. They gave their opinion.
Yes, diagnostic psychometry done from WBC on 8th of September. When was the review medical board?
Review on 25th July.
25th.
No, I'm sorry. 31st July.
2023.
Diagnostic psychometry as per cared history, behavioral and psychology test may reveal an average level of intellectual function with compulsive trait in his personality.
Then another doctor, Malad.
How does this improve your case, Mr. Rai?
Malad, another report, Malad, your lordship, Dr. Rita Sarkar, But your lordship will find Dr. Rita Sarkar has said that person is clinically and psychologically fit
at present.
As per extinct psychometry.
Mr. Rai, psychiatric patient in this sort of a force, it might create problem.
But that is one aspect of the matter. And for the other aspect,
We could have Mr. Roy, kindly come to page 33.
the different tests were undergone
Page
at the
Page
Malad.
33.
Malad.
Kindly see presenting
I've seen Malad.
background information.
Yes, Malad.
According to he was involved in a relationship in 14. Relationship not so due to his impulsivity, he decided to cut with a blade just to seek the attention of his fiancée.
Malad, it is not uncommon, but Malad, one thing, Malad,
What did the court say? What did the court say?
Malad, one thing, this particular report which I have just placed before your lordship, that is obtained from Malad, from the district hospital, that was not placed or that was not considered by the Malad trial court.
We are considering.
Malad, that's that. Malad, one aspect of the matter, your lordship, if your lordships can, Malad, subject to lordship sanction. Malad. This is the
Mr. Roy, can you come back tomorrow? We have a bench at
yes, Malad. Yes, Malad.
What is that you are
Malad, there is a provision that after Malad, after the review, even there are Malad, there is a specialist opinion or other opinion, they may consider this Malad the afresh. Malad, that part, Malad, that
This is the guidelines.
well, this is
It is the guidelines.
Malad, tomorrow I will come.
Abar ki
Well, tomorrow, Malad, tomorrow I will come. Malad, a boy, Malad, having Malad the
We appreciate your friend told us. We are aware of that. But Mr. Roy, kindly ascertain there is an element of risk. The trial judge has expressed that. Now that discretion which was applied, that cannot be said to be a wrong discretion.
No, I'm not on that.
So in that case, appeal, how do we interpret?
When the discretion was exercised, then this report that he is now physically fit, that was not taken into consideration. And that be so, that's why the provision I will refer it from the their guideline. But that I will refer it tomorrow.
Tomorrow at 11 o'clock.
All that I can place before your lordship. I have
we have full sympathies, but the thing is, Mr. Roy, how can we do if that is not possible? Anyway, come tomorrow and
next matter, I'm kindly excuse me, disturbing your lordship. But next matter, I may seek for the adjournment for 2 weeks because of the.
Ask your junior to be here.
Yes.
Item number 1.
My lord, I am for the petition.
Mr. Mittal is appealing for the respondent.
বলো আমি তো petition respondent.
হ্যাঁ দুটো ওনাদের এই তিনটে ওনাদের
জাজমেন্ট যেগুলো দিয়েছিল
যে জয়ন্ত বিশ্বাস এইটাও ওনার মহাপাত্র না ওইটা দ্যাট ইজ এইটা ওনার মিত্র এটা এর সাথে বেঁধে রেখে দিই
আরো একটা আছে। আচ্ছা।
কি করে দিচ্ছি in the said conspectus and as the alleged charge of molestation did not survive and as the incident was not related to the duty of Bishwanath, the learned single judge rightly came to a finding that the orders passed by the disciplinary authority, appellate authority and the divisional authority had caused grave miscarriage of justice. The order does not suffer from any jurisdictional error warranting our interference. Writ petition and connected applications are dismissed. অ্যাপ্লিকেশনস আছে দুটো আছে নাকি একটা স্টে ওয়ান অ্যান্ড ফোরটা কি দেখলো কি অ্যাপ্লিকেশন একটা স্টে আর একটা কি ভেকেটিং অ্যাপ্লিকেশন ছিল তাহলে তো চেঞ্জ হবে এটা কোনটা ক্যান এটা তো অ্যালাউড হবে এটা তো ওদের অ্যাপ্লিকেশন ফর ভেকেটিং কিছু লাস্ট বেড়াতে পারে এইটাই করতে হবে আর আরেকটা অ্যাপ্লিকেশন কোথায় হুম? এইটা একটু দেখে এক্ষুনি ছাড়বার করে না ওটা নিয়ে যাও আমি করে দেবো
17 is ours. This one, no? This. May it please your lordships, my lord. But on the last occasion, my lord, I failed to present myself, my lord, when the case was called, my lord, when this case was called, my lord. This is the, my lord had asked me, my lord, about the status of, my lord, the affidavit in reply, my lord.
What is?
17 is,
Where is the petitioner? He's not.
Petitioner appeared that day and he was very vociferous that no copy of the reply was supplied to him. Now I'm here with proof, my lord, that it was filed on the 24th of November before the Central Administrative Tribunal, with copies being served upon, my lord, the
24th November.
24th of November.
When is the next date?
The next date is, my lord, on the January? 17th of January, my lord. And in fact, my lord, on the last date, my lord, on the last occasion before the my lord, learned Central Administrative Tribunal, that is on the 18th of October, now the petitioner himself did not appear.
We pass it over, Mr. Bhattacharya.
Or, my lord, it is there, my lord, the proof of my lord, the
We
filing.
can pass the order in his presence that he came and said.
But I understand the chances of Mr. Felix appearing now is remote, my lord.
What do you do? Dispose it or keep it for? Let us pass
Very
it
good.
over. What?
Very good. Very good.
Or if you are not there, hand over to your junior.
My lord, by way of abundant caution, my lord, I am also here, my lord, with another extra copy of the affidavit in reply. So that,
Yes,
my lord,
yes. Or let us call the short password. Let
my lord,
Do you know him? Do you have his number? You can contact him and
just call him up. Just say,
Password
next
to it.
matter আমার কিছুক্ষণ চলবে. Please ask him to come so that he has at least দেখো আমার brief নিয়ে চলে যাও না. না. May it please your lordships, my lord, I beg to appear on behalf of, my lord, the petitioner. My lord, before I, my lord, begin my case, my lord.
Sorry, where you people run? He was here. He is with the report.
My lord, I'm sorry.
একটু ওটা আগে দাও শেষ করে দিই।
I beg to appear for the petition, my lord.
Yes.
My lord, I'm filing my affidavit of, my lord, I'm filing my supplementary affidavit rather.
What is that against supplement?
My lord, this is regarding the next date of hearing fixed by the learned tribunal, my lord. It's on the, my lord, page 7, my lord.
Very good. Show us the last order which it is noticed that accelerated 4 weeks time was granted.
January date.
Is the instruction 17 January from the department.
Okay. So, দিয়েছে কোনো?
আমাকে দিয়েছে।
দাওনি কেন? আমাকে দেবে তো? এখন দেখাচ্ছ। আগে বলেছো সাপ্লিমেন্টারি কি বলেছে?
এটা করেছে ওই রিপ্লাইটাই ফাইল করার কথা বলেছে they are agree because
Now they have already filed the reply.
No, my lord, no copy has been served upon me, my lord.
We are serving you here.
Let it be so, my
I'm
lord.
here with an additional copy. My lord, though the system, my lord, before the learned Central Administrative Tribunal is, my lord, it can be filed, my lord, only upon an endorsement of service, my lord. Otherwise, it cannot be filed. But, my lord, I will discount that, my lord, that controversy, my lord. I am here with, my lord, another additional copy of the reply.
What is this you have given?
But this is from, my lord, the filings. This is, my lord, from the server of, my lord, the Central Administrative Tribunal, depicting the fact, my lord, that on the 24th of November, my lord, at the bottom on the first page, my lord. On 24th, my lord, the reply has been filed, my lord.
Filed in the court?
Yes, yes. And, my lord, the system there, my instructions are, my lord, that first, my lord, it has to be endorsed on the rejoinder of the judge's copy, my lord, that it has been served, my lord, upon the, my lord,
So, what
concerned
is
party.
your supplementary evidence?
My lord, this is regarding the next date. Your lordship asked me to file a supplementary affidavit bringing the next date on record, my lord.
What is when?
17th of January, my lord.
17th, I already.
My lord, the only difficulty is that I am protected by an order of this court, my lord, division bench, my lord, to dispose of the matter out of turn because
Where
this
is
is a
that?
promotion matter, my lord.
Where is that?
My lord, the other to brief.
Brief.
No, the High Court brief.
Amar brief. Please. Here, please take it.
What is annexure P1? What is your case before us?
My lord, I am only praying for my lord that the
You
matter.
are praying, understand what happened? You previously approached this court.
Yes, my lord.
For what?
My lord, for promotion, my lord, and this honorable High Court was pleased to direct the tribunal, my lord, to decide the matter afresh regarding promotion, my lord.
That order.
My lord, I will place that, my lord. That is on page, my lord, 19, my lord. I'm sorry, not 19, my lord. Yes, my lord, page 19, my lord. Annexure P2, my lord.
We don't understand. This is an application for modification you filed. What is your case?
My lord, page 19, annexure P2 is the order, my lord.
What is the order?
My lord, the writ petitioner concerned is granted him leave on to approach the lineage tribunal for the self-same relief of promotion, my lord. Or a
This refers to WPCT 90 of 2020.
Yes, my lord.
Where is that 90 of 22? This is what you have annexed is page 12 is WPCT 60 of 2015.
My lord, 90 was the last writ petition before this honorable court, my lord. Praying for promotion, my lord.
My lord, may I be permitted, my lord, to my lord, iron out the creases, my lord?
Yes, yes.
Yes. But as I understand, my lord, from the order impugned is dated 9th of August 2023, whereby, my lord, an application was made, my lord, for preponing the date of hearing. My lord, we'll find that order at page 21, my lord, of the application of the, my lord, the WPCT application. There was a prayer made on behalf of the union before the Learned Central Administrative Tribunal for filing of reply so that pleadings can be completed. Accordingly, on 18th of October, the matter was posted. Being aggrieved from this order, my lord.
We understand, but what were the previous litigations? He says High Court has passed an order on 17th February. Liberty was granted to approach this tribunal on perusal of annexure. It has been noticed that this is another original application. Do you understand? I don't understand. We do not understand what is your.
My lord, pursuant to the order dated, my lord, passed in WPCT number 90 of 2000.
Where is that order?
Page 19, my lord.
Page 19 is WPCT 60.
Annexure P2, my lord.
Annexure P2.
P2, my lord.
Page 19.
Page 19, 19.
This is into what? Having considered.
This is the last order, my lord.
As far as the petition, we grant him to approach the. So on the basis of this, you filed a fresh petition.
Fresh original application before the tribunal, my lord. That was admitted. That was admitted, my lord, in which they were asked to file reply, and I was asked to file.
Just a moment.
My lord.
Now that was admitted when to page 20.
Yes, my lord. Yes, my lord.
Now it was fixed on 12th of June 2023. Now then next order is 9th of August 2023.
Yes, my lord.
Now there you filed an MA application for what?
For fixing of an early date of hearing, because, my lord, I was protected by an order of this honorable court, my lord, to take the matter expeditiously. Since, my lord, I am going to retire shortly, my lord, the promotion matter, my lord, may be taken up expeditiously, my lord. So I asked them to, my lord, take up the matter without the reply, because they were not filing reply in spite of, my lord, 3 occasions, my lord. They failed to file the reply, my lord. And the matter was sent before the registrar court to complete the pleadings, and thereafter the matter will be placed before the regular court, my lord. This is the system in the CAT, my lord.
Now when is the next date?
Next date is on the 17th, my lord. Have you filed the supplementary affidavit, page 6, my lord.
That is before the bench.
Yes, my lord. No. That is before the, my lord, learned registrar, my lord. The matter has to be posted before the regular court, my lord. Lordships kindly, my lord, pass an order, my lord, to take up the matter in the month of January for hearing, my lord. Peremptory hearing, my lord. That is all I am asking, my lord. I will file reply within 1 week, my lord, from today, my lord, to the original application.
The present writ petition has been prepared.
Thank you, brother. Grateful.
Springটা দেবেন।
Oh, sorry.
On the basis of this order, there was an observation is about to detail shortly. Tribunal may take up the matter out of my disposal. Now, when this High Court order was there, they did not, what did the court has taken into condition that notice issued matter directed to be listed on 12th on receipt of notice appears and request to allow file time 4 weeks time has been granted, listed direct to be listed for completion of pleadings on 26. Matter was passed as we will record that in view of the earlier direction of this code, and since you have already used
Yes,
it,
we have filed the
matter may be disposed of as
yes,
it.
my lord, may only my lord, kindly take note of one fact also, my lord. On the last 2 occasions before the learned Central Administrative Tribunal, that is on 26/7/2023 and 18th of October 2023, my lord, there was no representation insofar as, my lord, the petitioner was concerned. No one appeared, my lord.
That was on 24th November. And
No, my lord, 26/7/2023.
where do we find them?
And my lord, I have the order sheets with me.
26/7.
Yes.
Adjourned with direction. Yes.
Yes, and 18th of October 2023.
Yes, he's right.
My lord,
You did not appear.
my lord, it's an empty formality, my lord. Unless the reply is filed, my lord, I have precious little to say, my lord. They will adjourn it, my lord, in any case, my lord.
It is an empty formality to come to this court, na?
No, my lord, I'm sorry for that, my lord. They will, my lord, adjourn it in any case, my lord. That is the, my lord, thing, my lord. Unless the reply is filed, my lord, they will give a date, my lord. That is the normal thing, my lord, in the
Then
tribunal.
why didn't you appear?
My lord, that is my fault, my lord. I did not appear.
Then why should we entertain your application? Records show that you did not appear, right?
Yes, that is a fact, man.
Present writ petition has been preferred. Mr. Bhattacharya, we dispose it of in the light of the earlier order which was. Huh? The present writ petition has been preferred, primarily paying for issuance of necessary direction of the necessary direction towards expeditious disposal of the original application being way number 482 of 2023 pending before the learned tribunal. Learned advocate, huh? So Felix learned advocate appearing for the petitioner submits that in spite of an earlier direction of the learned tribunal, no reply was filed by the respondents, and as such the matter could not be taken up for final hearing. Per contra, Mr. Bhattacharya, learned assistant, learned appearing for the respondent submits that the matter had to be twice adjourned on 26/7/2023 and 18th October 2023. Since no one appeared on behalf of the petitioner hearing. However, the respondents, the petitioners on 24th November 2023. That day also they did not appear. Now that day
Order to the 24th date ছিল?
No, 24th there was no date.
But 24th it was filed.
There was no date, my lord. Next
On
date is
18th
the
of October, it was fixed on 17th
20th
of
of Jan
January.
is the next date, my lord.
And in the meantime, my lord, on 24th of November, it has been filed. So it was, my lord,
17th of January, it has been fixed. কি লিখলো? Stop. However, no, stop. However, reply on behalf of the respondents have already been filed on 24th November 2023, and the next date has been 24th November 20. Stop. A copy of the reply has been handed over to Mr.
Please.
Felix, learned advocate in
My lord,
court
I have
today.
received, my lord.
So Mr. Felix, answering our query, Mr. Felix submits that the next date for hearing has been
Yes.
fixed on
17th of January.
17th of January 2020. Records reveal that the petitioner earlier approached this court by filing an application, writ petition being WPCT 90 of 2022, which was disposed of by an order dated 17th of February 2023. Observing inter alia that, quote unquote, as it is stated that the writ petitioner is about to retire shortly, the learned tribunal may take up the matter out of turn and dispose of the same as early as possible. As the respondents have already filed their reply, the petitioner is directed to file the
Rejoinder.
rejoinder within a week from
For 1
date.
week, my lord.
Within a
kindly
week.
make it peremptory, my lord.
Yes, yes,
fine.
without fail, my lord, without fail.
In view of the earlier observation made by the honorable, made by a coordinate bench of this court in WPCT, we numbered the WPCT 90 of 2022, we dispose of the present application in view of the earlier decision, it is expected that the learned tribunal shall finally decide the application as expeditiously as possible without granting any unnecessary adjournment to either of the parties. Disposed of, no order.
My lord, kindly mention some time, my lord. Some time, my lord. 3 months time, my lord.
Amend your conduct and then say.
Sorry, my lord. Much obliged, my lord.
But this matter, my lord had considered, my lord, these matters on the last occasion, my lord. This pertains to, my lord, but the termination of services, my lord, of the petitioner herein, my lord, who was a civil motor driver
Yes, Mr.
in the Indian Army. My lord, before I begin my case, my lord, there was a query from your lordships, my lord, on the last occasion that the incident took place on the 12th of January, but the statements which are there appended to the petition, they are dated 14th of January. So I indicate February. But I indicated that there must have been some field inspection. So later, my lord, we found out, my lord, owing to inadvertence, my lord, those statements, my lord, those were not annexed to the petition, my lord. Whatever was recorded, my lord, at the spot inquiry on the 12th, my lord. So, my lord, I am just bringing it on record by way of supplementary affidavit, my lord.
Other side.
Yes.
Have you served up?
I will, my lord, right now. আমার কপিটা দিন একটু
And another question which had fallen from us was, you had terminated him in terms of rule 14, if I'm not mistaken. 5. But the inquiry had been done in terms of rule 14.
My lord, I'll come to that, my lord.
So you were
have-
just asking that are you ready to take him back?
But I have, my lord, the departmental circular also with me, my lord. But I'll just place, my lord, the facts of the case and the law applicable thereto, and thereafter I'll leave it to the lordships, my lord. But already, my lord, the fact remains, my lord. I cannot deny the fact, my lord, that already this particular order, my lord, the learned Central Administrative Tribunal, my lord, has already quashed this order with a direction, my lord, granting us liberty, my lord, to initiate fresh action, my lord, if so desired. So against that, my lord, there is a stay of operation of the order by your lordship's, my lord, honorable bench. So it is not that, my lord, that the petitioner is deprived, or my lord, he is already, my lord, his rights have been already, my lord, adjudicated, which as of now is stayed by virtue of, my lord, judicial interdiction by your lordships, my lord. So
Adjudicated means
adjudicated before the learned Central Administrative Tribunal, adjudicated in his favor rather, my lord.
right.
So, my lord, I'll just, my lord, very briefly, my lord, the supplementary affidavit that, my lord, I have brought on record, my lord. So, if, my lord, the first two depositions, my lord, of the persons to whom, my lord, the phone number was supplied by the petitioner herein, my lord. Now, that is in vernacular. So, my lord, may kindly
Did
skip.
you place those records before the tribunal? How can we take it on record? That was not.
No, my lord, that was a query from your lordships, my lord, that how can it be 14th when it happened on the 12th, my lord?
That you cannot explain now. That is
No, no,
our query.
it was there, my lord. That is what, my lord, we intend to indicate that no, it was not an action, my lord, which was taken, my lord, with a closed mind. It was there.
Where do we find it was there?
Yes.
Kindly come to page 22 first.
My lord, 22 of the petition, my lord. My lord.
Kindly paragraph 5.
My lord.
Paragraph.
Statements given by both the candidates are also attached as appendix B and C. Now,
So now you have annexed along with that pages 24 to 25.
yes, my lord. So, my lord, this was out of inadvertence, my lord. This is dated 14th of February, my lord.
So this statement is not a true statement.
No, this is subsequent, my lord. This is during, my lord, the inquiry, my lord, which followed.
When was the inquiry done?
My lord, inquiry was on the 14th of February.
Please have that page 23.
23.
At
Yes.
the bottom
Yes.
page, there's a overwriting.
Yes, I have seen that. I had specifically asked also that I find that it was initially 12, then 14. So why was that done? So, my lord, my instructions are, my lord, it was, my lord, a clerical error, because the next statement also, my lord, will find it's 14th only. The next statement, the next page, page 24, my lord, will find it is dated the 14th, my lord. 25 also, my lord, it is dated the 14th. And it is 14th, my lord, that will be supported from the fact, if my lords kindly take pain to take page 28, that is the...
You issued that letter on 12th February, annexing certain documents which we say that it has been inadvertently annexed.
No,
Those were not
my lord's query, yes.
Let us understand the factual. 12th February was the incident report.
My lord.
And you, page 27, this letter is of 13th of February 2018. This is the board of officers composed as under will assemble at rally site to inquire into the circumstance under which was influencing while such and such.
Yes.
So the supplementary affidavit documents, are those documents placed before that board?
Yes, yes. The board considered the, my lord, these documents, my lord, which I am introducing by way of the supplementary affidavit. That is, my lord, the
What is the date of that?
This is 12th of February, my lord, the date of occurrence.
So 12th, this was considered by while passing the order at page 22. Yeah, that is what is contained.
My lord, this was also taken into consideration, my lord, in the inquiry, my lord, by the board of officers, which was, my lord, which commenced on the 14th of February. My lord will find that 14th of February at page 28.
Where do we find the date, Mr.
Page 28, my lord, kindly takes, my lord, the third head on the day of 14th of February 2018 and subsequent dates. And it was, my lord, vide the order of the headquarters recruiting zone, Kolkata, dated 13th of February 2018.
So on that date, you obtained fresh declarations?
Yes. But on that date, my lord, yes, further statements were also, my lord, taken, my lord.
Of the witnesses also?
Of the witnesses also, yes. Of the witnesses also.
So what was the necessity for twice obtaining statements from them?
No, my lord, what I am trying to indicate is that, my lord's query was, my lord, on the last occasion.
If a reply has been obtained, why Mr. Bhattacharya, you will again come and say another reply is required?
My lord, that was done, my lord. That statement, which was recorded on the spot, my lord, that was not, my lord, recorded, my lord, by, my lord, the board of officers, my lord, who were, my lord, causing the inquiry. That is on the 14th. And, my lord, in any event, my lord, I find, my lord, there is not, my lord, any difference, my lord, in so far as, my lord, the tenor of the statement are concerned.
No, we are more disturbed because there are two statements.
My lord,
We are disturbed because there are two statements. It's not about the tenor of the statement.
my lord.
What is the need to have two statements? Because once you have already recorded a statement, that could have the same.
Ideally, it should have been on the statement, my lord, which was obtained on the 12th of February itself.
That is the problem which we are finding in this entire thing, that ideally what should have been done has not been done.
My lord, sir, just a second. No, my lord, I am trying to bring in these records to demonstrate, my lord, that there was no, my lord, premeditated stand in so far as, my lord, the, my lord, army is concerned. Because my lord's query on the last occasion was, my lord, that how can this memo be there on the 12th of February, which is supported by a statement dated 14th of February?
That was one of them.
Yes. So this is, my lord, just to demonstrate, my lord, that no, there was no closed mind or no mechanical action. Or it was never prejudged. So whatever the materials were there on record. It is not that this particular memo of 12th of February was in the absence of any materials.
Yes.
Yes, my lord, this is one, my lord. My lord, if my lords may kindly permit me, my lord, I'll, my lord, place, my lord, page 7 of the supplementary affidavit, which contains, my lord, the statement of, my lord, my lord, the employee here in, my lord. Because, my lord, the previous two statements, my lord.
Mr. Bhattacharya,
My lord.
where in your reply to the tribunal you have said this, that it has been inadvertently done?
No, my lord, this inadvertence, my lord, it was pointed out, my lord, on the last occasion when the hearing was taking place by your lordships, my lord. Even I had also missed it out.
No, in reply you must have stated that the inquiry was on the basis of the 14th February letter and not the 12th February letter.
No, my lord, this was.
What is your stand in the tribunal?
This was never, I understand, my lord, the subject matter of, my lord, adjudication before the tribunal.
This was the subject matter.
No, my lord, this 12th and 14th, my lord. But this question, my lord, possibly, my lord, this came up for the first time before your lordships. Reply, did they annex these documents at all? No, any of these documents, I mean, the statements dated 14th of February and all, was it annexed to the reply?
You must have annexed these two documents only before the tribunal.
Let me kindly, my lord, bear me for a moment.
Hmm.
We have a copy of the original reply that we filed before the tribunal. Can you please check up if it was made an annexure or not? To annex documents, you do not provide the annexures. 121 is the reply, sir. 121 the reply. Yes, please check up whether it was at all annexed or not. You have annexed the reply, but it does not contain any of the annexures. No, reply cannot be without annexure. There are exhibits which are referred to in the reply.
These reports were not made. No, this annexure. These annexures were also not before the trial. Mr. Das, you must have annexed in your original tribunal application, did you annex the statements?
Oh, no, my lord. In the original tribunal application, my lord, he had completely suppressed this fact. We brought on record, my lord, by way of the reply, the fact that no, these incidents also took place.
Where is that? Then you must have annexed, Mr.
My lord, I find, my lord, the reply that was filed before the tribunal is, my lord, without any annexure, my lord. My lord will find the reply. It starts from page 121.
There's no marking of any.
Well, there were no annexures, I understand, my lord. Insofar as, my lord, any of these documents are concerned, my lord. My lord, the 14th of February document, my lord, was also, my lord, not a part of the reply. In fact, they are not, my lord, because I find, my lord, in this petition also, my lord, these documents, my lord, precede the reply. So these are, my lord, documents, my lord, which I understand have been annexed for the first time, my lord, in the WPCT application.
How these things are happening, Mr. Bhattacharjee?
But I came in at a subsequent stage, my lord.
No, I'm not talking about you. I'm saying that how your officers have proceeded. They do not annex the right documents. They do not, thereafter they think that now let us bring certain documents. They now bring the documents. When the court questions, they come with further documents. That every day you are shifting your stand.
No, my stand is, my lord, that the documents were there, my lord. That I had indicated also, my lord, that there must have been documents, my lord.
Mr. Bhattacharjee, we are sitting in judicial review.
I completely understand, my lord. My lord will not travel, my lord, beyond the Wednesbury principles, my lord.
Now you are asking us to disbelieve these documents and to be with you to this effect that fresh documents are there which were taken into.
No, my lord, my endeavor, my lord.
How we are to know that tomorrow this may have been prepared? How we are to know when the court comes with your officers come with separate documents?
My lord, if my lord's desire, my lord, we can produce the entire records also, my lord, in original.
The way this particular proceeding.
But the entire file is there, my lord. We can produce the entire file.
Was the file?
Yes.
Do you have the file?
Sure, right. These depositions.
Original initial report in the original Sumatra 12th one.
And thereafter that 14th one.
14th one.
पहले ये दिखा देते आपको
14th one.
Have you checked up, Mr. Bhattacharjee?
My lord, I find, my lord, the original 12th document is there, my lord, with the original.
All right, you proceed with the case. No
Yes.
My
lord, I'll come straight away, my lord. My lord, to page 7 of, my lord, the supplementary affidavit, which contains, my lord, the statement that was given, my lord, by my lord, the private respondent.
Same statement which you
Yes,
have
yes, yes. But this is in English, my lord, so it will be convenient, my lord.
Oh, no. We can read vernacular.
My lord, let me start with, my lord, page 7. Thereafter, my lord, I'll refer to the vernaculars, my lord. But this is the statement of Soumitra De. Page 7, my lord, of the. Sir, may Soumitra De, son of Upendranath De, resident of such and such, Hooghly का रहने वाला हूँ. May 7 December 2017 से ARO GD गोपालपुर में सर्विस करता हूँ और इस समय मेरे ड्यूटी रिक्रूटमेंट रैली कृष्णनगर डिस्ट्रिक्ट नदिया वेस्ट बंगाल में लगी है. आज 12 फरवरी 2018 को मैं 2 कैंडिडेट को मोबाइल नंबर सच एंड सच दिया और मुझे ये गलती करते हुए हविलदार पी.के. द्विवेदी ने पकड़ा है और मेरे रिपोर्ट एआरओ बहरामपुर के बहरामपुर के एसएम साहब और डायरेक्टर साहब को दिया. So this is, my lord, what, my lord, the delinquent states, the, my lord, private respondent states, my lord, and thereafter pages 5 and 6, my lord. Honorable Justice Kant may kindly pardon me, my lord. It's in vernacular, my lord. I'll just read it out and thereafter translate it, my lord. Though, my lord, my ability to translate is very limited.
Translation I won't need. That much I.
Very well, my lord. But the name of the candidate is Azhar Sheikh. Father's name, address, etc. thereafter is given. Then Mahasay, today on 12th of February 2018, I went to the Krishnanagar rally. আমি দ্বিতীয় এটা কি দ্বিতীয় কি oh sorry I participated for the second time.
You read it Bangla.
Okay. I'm sorry, my lord. আমি দ্বিতীয় শুরুতে
My lord knows Bengali.
দ্বিতীয় শুরুতে মাঠ করেছিলাম। পাশ করার পর যখন আমি এআরওতে ছিলাম তখন একজন আর্মি আমার ব্যাগের মধ্যে নম্বর দিয়ে আমাকে বলল মেডিকেল পাশ করার পরে এই নম্বরে কল করবি। আমি তাকে কখনো দেখিনি বা চিনিও না। নম্বরটা যে কি নম্বর আমিও দেখিনি। স্যার আমার সাথে ওনার কোনো সম্পর্ক নেই। স্যার আমি যা বলেছি সত্যি বলেছি, আজহার শেখ। So this is one. The next statement is, my lord, is by one Shanyashi Mondol. It is also on similar lines. Mahashay, आज 12th February 2018 এ ভর্তি होने के लिए কৃষ্ণনগর র্যালিতে এসেছিলাম। আমি দ্বিতীয় গ্রুপে রান করেছিলাম। পাস করার পরে এআরও কে একজন কাগজে এক নাম্বার লিখে দিল আর বলল আমাকে কল করো। এইসব করাবার সময় এক ফৌজি আর্মিতে দেখে নিয়েছিল আর দুজনকে ধরে পরে সাবজির কাছে নিয়ে গেল। আমি ওই লোকটাকে কোনোদিন দেখিনি ও চিনিও না। এই বয়ান আমার নিজের ইচ্ছে আমি দিচ্ছি, কেউ কিছু বলেনি, যা বলেছি ঠিক বলেছি।
Yes.
Well, this is, my lord, on the date of the incident, my lord. And, my lord, the fact remains, my lord, that the private respondent herein, it is not a case, my lord, that he had no experience or knowledge about, my lord, the degree of transparency, my lord, that is to be followed or observed, my lord, when it came to, my lord, the army recruitment, because he himself is an ex-serviceman who is on a civil post. So, explained. And, my lord, there were, my lord, elaborate briefings, my lord, which were also being made, my lord, which were given, my lord, before the rally, that there should not be any interaction with any of the candidates.
Yes. So this
was, my lord, on the basis whereof.
Very good. Now kindly come to page 27.
Page 27, my lord. My lord. So, my lord, 27 is the 13th February memo, my lord, on the basis whereof the 14th February inquiry, my lord, was held, my lord. So 14th February, my lord, what transpired, my lord will find, my lord, Shoumitra's statement
No,
at
no,
page.
please place this.
Yes.
As part. This is not a. This is sort of a preliminary inquiry, not a departmental proceeding.
It's a preliminary.
The board of officers was composed such and such,
Yes.
caught illegally now.
Yes.
Your attention is drawn to Swami Manu disciplinary procedure for central government. Rule 14.
This is wrong because, my lord, he is a temporary employee on probation. So in his case, my lord, the rules pertaining to, my lord, I'll come to the rules, my lord. I have the rules with me.
So according to you, this was a wrong quotation.
Yes, yes. This is just, my lord, mere, my lord, quoting of, my lord, a wrong provision, my lord.
Now that was done on 13th of February.
13th, my lord, on the basis whereof,
14th was the report.
Yes, yes. 14th, my lord, the inquiry. So, my lord will find page 29. the statement that was given.
That has been.
Yes, my lord, I'll read it out once again, my lord. I have reread it, my lord, during the weekend, my lord.
What do you want to show us?
Yes. My lord, witness number 1, he was the witness number 1. He states that I am Soumitra De of such and such. I reported on 7 December 2017 after selection to ARO Gopalpur. I was detailed by my unit to be part of the screening team for the recruitment rally being held at Krishnanagar by ARO Behrampur. With my unit, reported to Krishnanagar on 4th of February 2018. This is my first rally. Now, on 12th February 2018, I was detailed to help in the registration process to obtain sample handwriting of all candidates and take them for registration after PFT test and before Aadhaar-based biometric. At about 9 hours, this is very important, my lord. At about 9 hours, I gave my cell phone number written on a piece of paper to 2 candidates and told them to call me later if they have any problem and I'll be able to help them.
Yes, we have seen
Yes.
that.
The paper slips, my lord, the paper slips, I put in the bag of one candidate. It was not, there was some motive, my lord. I put in the bag of one candidate and in hand to other candidate and assured them for adequate help.
Yes, you are absolutely right. This was adequate material to recommend a disciplinary action. That is exactly what you did, page 47.
Yes. Thereafter, my lord, kindly takes page 30, my lord.
30 is the statement.
Statement
again.
continuation, my lord.
No. Outcome of this is what?
No, my lord, I'll just, my lord, may kindly, my lord, appreciate, my lord. Question 2 and the answer given there too. Before the rally, was adequate briefing given to you at your unit? Yes, a Sainik Sammelan was conducted where in the DIR discuss all matters and specifically told to be vigilant and not indulge in any unfair practices at any time. However, at that time, I was on duty outside unit. However, on first day, the SM briefed all of us to ensure no unfair practice takes place. And thereafter, my lord, question 6. Do you know using unfair practices will result in disciplinary action? The answer is yes. And question 3, if read, my lord, in the light of, my lord, an admission, who all were involved with you in this unfair practice, he says that no, in this unfair practice, no one else apart from me, no one else. It was only me who was involved.
Yes.
So, my lord, what I am trying to, my lord, demonstrate, my lord, from these statements is that, my lord, this is the case, my lord, which leads to a clear admission by the candidate, by, my lord, the private respondent herein, my lord, of having adopted, my lord, means which are not fair in the, my lord, field of service pertaining to, my lord, defense personnel, my lord. The service pertaining to, my lord, army, my lord, which is of the highest, where, my lord, the highest of integrity has to be maintained, my lord, because of the fact, my lord, that, my lord, the army is entrusted, my lord, with protecting, my lord, the nation. My lord, the degree of, my lord, cautiousness and transparency, my lord, has to be at, my lord, the highest threshold, my lord. That should be the threshold, my lord. Some of the findings are there at page 45, and thereafter the opinion is at page 47. My lords have read it on the last occasion. My lord, what? Now, my lord, I will say is, my lord, now, my lord, if we take the rules now, rules are copy. Are a copy? My lord, I tender my apology, my lord, for it being stapled, not being stitched, my lord.
Must be in record.
আগে দেওয়া থাকলেও একবার দিয়ে দেখি আছে
Rules you have given to us, this one.
Yes, but the temporary rules of 1965.
Okay. This is what you have received.
But this
Central Civil Service Temporary
yes,
Services.
yes. But this is Central Civil Services Temporary Service Rules 1965.
It was heard by any other base?
Yes. Well, it was heard initially by one of the division bench presided over by the Honorable Justice Tandon.
And Justice Velumani.
Thereafter, my lord, it was heard by Justice Velumani.
Yes, already. What you are showing?
Yes. Now, my lord, an appreciation, my lord, of the Temporary Services Rules of 1965 will show, my lord, that the action which has been taken apropos, my lord, issuing, my lord, the termination simpliciter is, my lord, absolutely, my lord, in accordance with, my lord, the provisions contained in the rules. If, my lord, kindly takes, my lord, Rule 5 once, my lord. Now, Rule 5 states, my lord, that the services of a temporary government service servant shall be liable to termination at any time by a notice in writing given either by the government servant to the appointing authority or by the appointing authority to the government servant. The period of such notice shall be 1 month, provided that services to such government servant may be terminated forthwith by payment to him of a sum equivalent to the amount of his pay plus allowances for the period of notice at the same rates at which he was drawing them immediately before the termination of his services, or as the case may be, for the period by which such notice falls short of 1 month. Thereafter, my lord, the procedure for tendering the notice, etc., my lord, that has been, my lord, stated. And there is also, my lord, ওই জায়গাটা দেখেন যেখানে বলেছে reasons cite করতে হবে না. This also stipulates, my lord, that my lord, no
reason is required.
No reason is required to be given. My lord, as an officer of the court, my lord, it is my duty, my lord, when I am placing the law, my lord, I will be placing the law in its entirety. So this is one, my lord, Rule 5, which, my lord, pertains to which governs the field, my lord, pertaining to termination of temporary service. And there is another, my lord, instructions, my lord, by the government of India, my lord, dated 1967, which pertains to, my lord, probationers. So that is also there, my lord, we'll find, my lord. It's my lord, government of India's order.
But how can you rely on that? That has not been applied. Rule 5 has been applied.
No, Rule 5 has been applied, and
By
thereafter, upon completion of 30 days, my lord will find, if my lord kindly takes, my lord, the
Yes. Notice of
order.
termination was page 48.
Yes, page 48.
Oh, in termination, you mentioned this headquarter.
Yes, page 51, my lord.
Yes, they terminate in terms of clauses 2 and 3.
Yes, the 2 and 3 of the appointment letter specifies, yes. So, my lord, what I am trying to, my lord, indicate, my lord, it is, my lord, my endeavor, my lord, to place, my lord, the case, my lord, in its entire perspective before your lordships, my lord. And also, my lord, considering the fact, my lord, that this is the first time I am having the opportunity to, my lord, also address, my lord, the Honorable Justice Kant also, my lord. So, that is, my lord, that whatever has been done, my lord, strictly, my lord, by following, my lord, the rules which are applicable. And also the fact, my lord, that, my lord, the virus of, my lord, this government of India's order, my lord, that was never under challenge, my lord, before the learned Central Administrative Tribunal. And without throwing a challenge, my lord, to this particular rule or this particular instruction also, my lord.
Which instruction?
My lord, the government of India's order read with Rule 5.
Act a copy. I find out. I have handed
You
over.
have given it?
That is there.
It is there, my lord.
That is there.
It is there.
Yes, that is there.
Where?
My lord, my lord, the page number starts from page 773.
No,
edition may different.
773.
It must be a different edition, my lord. If my lord may kindly hand it over to me once, my lord, I'll just find out.
773. 773 is not.
I'll just find it out for you.
Different edition.
Must be from a different edition. Yes. But 759, my lord. I'm sorry, my lord.
Yes.
My lord, Justice Kant has also my lord, found page 759. So it specifies, my lord, about the government of India's order, which is dated 26th of August 1967. So it states, my lord, that a question has arisen whether this rule should be invoked also in the case of persons appointed on probation, where in the appointment letter a specific condition regarding termination of service without any notice during or at the end of the period of probation has been provided. The position is that the CCSTS rules do not specifically exclude probationers or persons on probation as such. However, in view of the specific condition regarding termination of service without any notice during or at the end of the period of probation, it has been decided in consultation with the Ministry of Law that in cases where such a provision has been specifically made in the letter of appointment, it would be desirable to terminate the services of the probationer / person on probation in terms of the letter of appointment and not under Rule 5(1) of the CCS rules, my lord. So, my lord, ultimately, my lord, these instructions, my lord, were relied upon, my lord, in issuing, my lord, the letter of termination, which, my lord, will find at page 51, my lord. My lord, I say, my lord, this is the case where, my lord, stricto sensu, my lord, the law which is applicable apropos a probationer who is pure, who is, my lord, on temporary basis also, my lord, has been applied, my lord. And, my lord, I say, my lord, this is, my lord, this case, my lord, also in the light of, my lord, I'll be relying on two decisions, my lord, by, my lord, the Honorable Supreme Court of India, my lord. The first one, my lord, is reported in, my lord, 1997, volume 2, Supreme Court cases, page 534. This was also, my lord, dealing with, my lord, the case of a probationer, my lord. 1997, volume 2, Supreme Court cases, page 534. The relevant paragraph will be paragraph 12. So I'll just read it out and hand over my copy to you. One of the ratio is, my lord, here also, my lord, it was dealing with, my lord, the case of a person on probation. Now, there was an allegation of sexual harassment where, my lord, there was an admission made. So the Honorable Supreme Court came to the, my lord, finding that no, there is no question.
Para 12.
Para 12, my lord. That there is no necessity of conducting a detailed and elaborate departmental proceeding. I'll just place the paragraph, my lord. Yes. My lord, may I place the entire paragraph?
Show us the relevant portion.
The relevant portion is, my lord, at the last page, my lord, the concluding portion of my lord, para 12.
In view of his admission.
Yes, in view of his admission, that he went to the room in night, though he shifted the timings from 10 p.m. to 8 p.m., which was not found acceptable to the respondents, and that he took the torch from the room, do indicate that he went to the room. The misguiding statement sent through Bharat Singh, the hostel peon, was corroborated by the statements of the students, but for the misstatement, obviously, the girl would not have gone out from the room. Under those circumstances, the conduct of the appellant is unbecoming of a teacher, much less a loco parentis, and therefore dispensing with regular inquiry under the rules and denial of cross-examination are legal and not vitiated by violation of the principles of natural justice. So here also, my lord, the case is very similar, my lord. It is a question of, my lord, employment in the defense establishment, my lord, in the Indian Army, where, my lord, a very high degree, my lord, high standard and degree of, my lord, transparency and caution is to be maintained. And despite, my lord, a session being conducted also, where, my lord, adequate warning was being also, my lord, spelled out, my lord, this has happened. And in effect, my lord, he has also admitted about sharing the numbers, my lord, with, my lord, the candidates, which by itself, my lord, is an act, my lord, which amply demonstrates, my lord, the motive. My lord, the second judgment, my lord, which I will be relying upon is, my lord, 1992, volume 4, Supreme Court cases. So please take my copy. 97 2. Yes, 92 4 Supreme Court cases, page 719. Kindly give me the other copies. I have it. Paragraph 6 to 9 will be, my lord, the relevant paragraphs, my lord. The ratio is, my lord, that when there is a termination simpliciter of a probationer, the question of lifting of veil need not arise.
We have not lifted the veil.
No, I understand.
God officers have lifted.
No, I completely understand, my lord. But I cannot retract from whatever is there, my lord. But also, my lord, I have to indicate, my lord, the fact, my lord, that this pertains to, my lord, employment under the Indian Army. There has been an admission, my lord. The action that was undertaken, my lord, the letter which was under challenge before the learned Central Administrative Tribunal, my lord, the memo was strictly in adherence to the rules, my lord, that I just placed, my lord. And I'll beseech your lordships, my lord, that considering, my lord, that the facts and circumstances of the case, my lord, may kindly apply, my lord, the ratio, my lord, which is, my lord, laid down in 1997, volume 2, Supreme Court cases, page 534, paragraph 12, my lord. My lord, may kindly allow my application, my lord, by
this judgment, Mr. Bhattacharya, which paragraphs here?
My lord, paragraph 6 to 9, my lord, but I will, my lord, rather heavily rely on, my lord, 97 2 SCC, page 534, my lord. My lord, these are, my lord, my limited submissions, my lord, and my lord, may kindly, my lord, pardon me, my lord, if my lords feel, my lord, that I have argued, my lord, and excessively, my lord, and my lord, wasted the precious time of the honorable court.
The original statement. Original statement.
Original statement, actually, the court believes that. It's not that, I mean.
Yes, Mr. Das.
My lord, kindly see my appointment order. For the very beginning, they are confusing, the officer also confused the court that I am a temporary appointment. I got a temporary appointment. It is not a temporary appointment. Page 21. Mr. Soumitra De, son of Mr. Upendranath De, you are hereby appointed as a civil motor driver, Group C, at Army Recruiting Office, Gopalpur, under Headquarters Recruiting Zone, Kolkata, with effect from 1st December 2007. Please report of Headquarters so and so. Now, second paragraph is very important. Initially, you will be on probation for the period of 2 years from the date of assumption of duty on temporary basis. On satisfactory and successful completion of probationary period, you will be considered for service as civil motor driver on permanent basis. Therefore, my the word probationer and temporary appointment, there is a difference meaning. Probationer means he has to complete the probationary period within a period of 2 years. Now, if I am a probationer, the rule which they have quoted cannot be applicable in respect of termination of a probationer. Now, they have issued a notice under sub-rule 1 of Rule 5 of the Central Civil Service Temporary Service Rule 1965. This rule is not at all applicable in respect of this particular appointment.
Since you are a probationer.
Since I am a probationer. The rule is said, my lord, my learned pen cleverly did not read this provision.
No, he has read.
No, he has not read a complete thing, my lord. I am reading the thereafter, my lord. But I have given the.
Where is your ground in the original application that the very.
My ground is, my lord.
Have you taken this ground?
I have taken this ground, yes. This ground I have taken.
Please show us your original application. It starts from page 54.
Yes.
Where is your argument, Mr. Das?
Yes, yes.
That was not the argument before.
Yes, I am submitting. Yes. Ground number XII, page 37. For the statutory rule, that is the Central Civil Service Temporary Service Rules.
Page 37.
Internal page 37, their page is 90.
90.
90.
Page 9. Yes. You have preferred an appeal.
Yes.
Has not been. You are saying that the temporary service rules have not been followed.
Yes, because there is a provision, Madam. How?
You are not a temporary servant.
I am a probationer.
You are a probationer.
Yes.
So your ground is against your contention.
Not, no, rule is, Madam, if there is.
Show us, Mr. Das,
Yes.
that you have taken a ground that they have done away with my service by applying a wrong provision of law. That is not there, Mr. Das.
Yes.
Anyway, you continue.
Yes. The.
On the contrary, your stand before the tribunal was that the statutory rules has not been followed. That is, temporary service rules have not been followed by them.
In these rules, Malad, there is a clause of 5.
No, so restrict yourself to your case, Mr. Das. Your case before the tribunal was not that you have wrongly applied the provision of law. Your case was that you have not complied with that provision of law of temporary service. That is the ground.
Yes. And Malad, in this particular.
Violates the provisions of Central Service Temporary Rules.
Yes.
This is, Mr. Das, you were not there, you are here, you are taking.
And that is not applicable in this respect of this, my lord. If your lordship see the paragraph 5, paragraph 5, my lord. Paragraph 5 of these rules, my lord.
Which rule?
This TCS Central Civil Service Temporary Service rules. But I have given the Xerox
What
copy.
is your stand? This applies or doesn't apply?
It will not apply.
Then why you are placing it?
Now, I am placing in case of probationer what rule says. In case of probationer, what this rule says, madam. That they have not read out before your loss.
Where you are reading?
But I have given the entire copy of this rule.
We also have the entire copy. Yes,
But para 5 lordship, can you see? I am giving my.
Yes, para 5. My lord has the copy. It's here.
Para 5 I am reading, madam.
Yes, yes.
A question has been as arising whether.
Wait. Para 5 of?
Para 5 of internal page.
This
rule I am reading, madam.
Rule 5 you are placing. Are you placing, say, temporary services rule 5?
Rule 5.
Yes. Then it's
now rule 5 internal page 12 of this.
My lord, he's possibly referring to page 759, my lord, the one that I read out, my lord, regarding, my lord.
All right.
Non-applicability.
Yes.
Not to be applied to probation.
A
question has arisen whether.
It was not cleverly, but I read it out, my lord.
A question has arisen whether these rules should be invoked also in the case of a person appointed on probation, where in the appointment letter, a specific condition regarding termination of service without any notice during or at the end of the period or probation, including the extended period if any, has been provided. The position is that the CCS-TS rules do not specifically exclude probationers or personal probation as such. However, in view of the specific condition regarding termination of service without any notice during or at the end of the probation period of probation, including the extended period if any, it has been decided in consultation with the Ministry of Law that in cases where such a provision has been specifically made in the letter of appointment, it would be desirable to terminate the service of the probationer of the personal probation in terms of the letter of appointment and not under Rule 5.1 of the CCS-TS Rule 1965. This is my number one submission. Number two, my lord. Last occasion, my lord has rightly taken this point that what is the opinion of the inquiry officer, inquiry board. They have recommended for regular disciplinary proceedings. After taking the witness, after taking all these things, the page 47 is very clear in respect of that. Now, page 47 of their petition, my lord. The page 47, no page, my lord.
47.
47, 48, here we give notice. 49.
Sort of statement. Termination of the most tribunal has decided on the point that the materials which you have brought up that is not sufficient to show it. But the argument here is totally different. Since we have said that when your own officers found that there would be a stigma because it is you have acted against the interest of others. Fraud you are practicing. On that the board recommended that any initiated but that was done in June 2000. page 47.
The Board of Officers is of the opinion that suitable disciplinary action must be taken against CMD Soumitra De by the competent authority or his unfair and illegal act for passing of sale them no written and so and so. Now, without doing so, they have straightway termination my service.
No, what
and
is this is 13th, this is 14th of February opinion.
12 February. There is
14th.
no date
No,
is showing, my lord.
This is the inquiry, the opinion pursuant to the inquiry which was on the 14th of February.
That you showed us 14th of February. So
14th.
this order is 14th of February. That we can take from you
Yes,
because we do not find the date here.
No, it states, my lord, that it was on 14th and subsequent date. So,
Then what is the date of this order, Mr. Bhattacharya? Inquiry was on 14th.
yes, yes.
Now, page 51, your notice of page 47.
47 must be 14th only, my lord, I understand.
14th of February 2018. Yes.
Now, my lord, if there is a simplification termination in the probational period, my lord, the appointment indicates in view of clause 2 and 3, service can be terminated. I will have no case before this tribunal or before your lordship. But if there is an inquiry behind the back of the petitioner or there is an inquiry, my lord, this in the respect of this aspect, they have totally bypassed Article 311 of the Constitution of India. In this particular matter, my lord, whatever judgment my learned panel cited, I think it is a
Judgment will come later, Mr. Das.
Yes.
Kindly come to the order of termination.
Yes.
What is the order of termination? What is the date of the order of termination? Page 51.
First of all, lordship, can you see the notice? Page 48, my lord. Page 48.
The notice is 11th.
Just a minute, sir, please.
There's
No,
a
no, no,
query
no,
from
we
the
are
honorable.
asking him. We are
There's a
asking.
query from the honorable court, sir.
11 June 20.
11th June is the notice.
And what is
And-
the termination at page 51? Date?
51 is, my lord, and date. Sir.
Date is that?
Well, date is 13th of July 2018. My lord, we'll find it at page 52.
13th of July 2000.
There is no transparency at all.
52.
My lord.
No date is there.
But this order at page 51,
My lord.
this was issued by whom? This was by the Deputy Director General.
Yes, the Deputy Director General, Headquarters Recruiting Zone, the respond number 4.
Who is enclosed hearing.
Yes.
The
13th
past.
July.
13th July.
Yes, Mr. Das. Anything else?
Now, yes, page 48, can you see, I have to read out the two sentence.
Page?
Page 48 of their petition.
Huh.
In pursuance of sub-rule 1 of Rule 5 of the Central Civil Service Temporary Service Rule 1965, a notice has been issued for termination. Now, who has issued? Deputy Director General, so-and-so, on 11 June 2018. Thereafter, my lord, see the termination at page 51. There is no date at all.
That was forwarded by page 52.
No date at all.
52 is in 13th of July. Read the 52 page.
Yes.
Order of para 2, order of termination in recess as a duly signed by DDG is enclosed hearing.
I am absolutely agree with the lordship, but if there is a signature of the person concerned, he will not put the date when he has passed this order. An order without any date is not an order. No date is there. Now, forwarded by somebody, my lord, DDG. Maybe he can forward the order in a subsequent date. But what is the actual date when the order of termination has been issued?
Kindly come to page 53.
No, 51 also, my lord, the date is there.
What's
My lord,
that date?
kindly take the stamp, my lord, its date is 13 July. It's written there. But kindly takes note of the stamp, my lord, left hand side, my lord, at the bottom. It's 13 July.
Yes, yes. Date is the 13 July. On the stamp.
What's that?
Yes.
It was served up you on 13th of July.
All right, my lord. Now the thing is, my lord, whether this type of inquiry in respect of this, in case of a probation, is permissible or not. Now, in our High Court has dismissed one cases. In the case of Dipti Prakash Banerjee versus Satyendra Nath Bose National Center for Basic Center at Calcutta. Matter has traveled to the Honorable Supreme Court. Now, what Honorable Matter I have given this judgment, my lord? Dipti Prakash Banerjee versus.
Yes, Dipti Prakash.
Yes. Now, Lordship, can you say I am reading
That
the.
was our initial judgment, High Court
Yes,
judgment.
yes, initial judgment. Now, Lordship, can you, what is the Honorable High Court has said and what the Supreme Court has said?
Have you given us copies?
Yes. Copy.
What you are saying, which
Yes.
order you are placing? Dipti Prakash you are placing?
Dipti Prakash Banerjee versus Satyendra Nath Bose National.
Yes, you have given it.
Yes. Now, Lordship, can you see? Paragraph. Last portion of this order. As pointed out in Bishan Lal Gupta versus State of Haryana 1978 1 SCC, an ordinary inquiry by a show cause might be sufficient for the purpose of deciding whether the probationer could be continued, but where the findings regarding misconduct are arrived at without conducting a regular departmental inquiry, then the termination order will be vitiated. The learned senior counsel for the respondent relied upon the Hindustan Paper Corporation versus so-and-so 1996 11-404, where it was said that for termination or lien, no detailed inquiry was necessary, and that if that be the position, termination of probation stand on a lesser footing, but the case turned up of a special rule. In that case, we specifically provided that on termination of liens, a regular inquiry was not necessary. That case cannot be therefore be of any assistance to the respondents. We do not find anything objectionable in the third letter, so the second letter as well. So, for the reasons stated, the appeal is allowed. The judgment of the division bench, a learned single judge of the High Court, has set aside. The impugned order of termination is quashed, and the appellant is hereby directed to be reinstated with back wages till the date of reinstatement. Now, my second judgment. This is the landmark decision, and till now it has not been overruled. It's a constitution bench decision of 7 judgment. Thamses Singh, madam. But I have handed over last occasion. But there are very important paragraphs are there regarding the probationer and temporary appointment.
You have given copies?
Yes. Got it, madam. এটা মোটা জাজমেন্ট আছে দেখো
For what you are relying on 300? This is
Yes,
311.
Yes, yes.
Oh, got it.
Totally bypass. Because they have made an inquiry.
Mr. Das,
yes.
Mr. Das, in this case, you are on the ground, this is a simpliciter termination or not? In the letter of termination, no opinion has been expressed as regards your conduct. Suitability, the employer has the jurisdiction to determine your suitability. Now, your ground is that when on the, what was the genesis? Genesis was the, on the date he handed over papers to the, to Anand.
That is not proved at all.
That is not required to be proved. Your argument is that there was a recommendation for disciplinary procedure.
Actually, they have made out my case.
Very
they have
good.
made out my case.
No, now today you suggest the employer decides it is not a regular disciplinary body. They constitute a team and they come to a finding upon granting you an opportunity that there should be a disciplinary proceeding.
Yes.
But not going forward to hold the disciplinary proceeding and issuance of termination, whether these are compatible or not. That is your argument.
That is the argument that Samshed Singh has clearly been discussed. If there is an inquiry,
If the inquiry are of different natures, one
Malad,
can
I am
be a
submitting, Malad.
preliminary inquiry.
Now, rightly or wrongly, they have proceeded with the inquiry by taking a witness. They have made out a case. If your lordship sees the reply, there is a, right now I can show the reply.
Yes, they said that we initiated disciplinary action.
If they conduct an inquiry, then I have a case because they have already conducted, it is an admitted fact. In the reply itself, reply also there is an admitted fact. But if they do not hold any inquiry, I will have no case at all. If they have held an inquiry, they cannot bypass Article 311 of the Constitution of India. That is the decision of the Samshed Singh Bada. I am reading one of the certain important paragraph. Now, first of all, Lordship kindly, I am reading internal page 5.
So where is the stigma, Mr. Das?
But I am not saying in respect of stigma. There is no stigma at all, nothing else.
Then why do we interfere?
I am pointing out before your lordship, my lord. If they issued an order of termination in terms of clause 2 and 3 of my appointment order, I will have no case at all. What they have done, they have made an inquiry. Whatever inquiry, preliminary inquiry, whatever inquiry they have made, they made an inquiry. Now, if they made an inquiry before termination, they have to give an opportunity. I have to get an protection of Article 3.
They did not initiate the proceeding.
They have, then my lord, how they have made an inquiry?
Kindly come to page.
That is the Supreme Court judgment, my lord.
Kindly come to page 47. What they have done.
Board of Officers.
Yes.
Disciplinary action should be taken.
Should be taken. They did not take.
But that is the wrong thing has been done by the office authority. The person concerned who has terminated me, he has disobeyed the opinion of the Board of Officers. They can't violate they have initiated Board of Inquiry. That means the inquiry was held, rightly or wrongly, preliminary or major, whatever may be. That is Supreme Court has said, it is totally unjustified. He has to give a protection of Article 311. But if I read this judgment, my lord, everything will be clear.
Kindly come to Deepti Prakash, paragraph,
Yes.
the last part which we are pointing.
Yes.
But where the findings as per Bishanlal, an ordinary inquiry by a show cause might be sufficient for deciding the issue whether the probationer could be continued. But where findings regarding misconduct are arrived at, without conducting a regular department.
Here misconduct.
No. Here no misconduct.
They have
been ousted on-
stated, I have handed over the slip to the other two person. It is a misconduct. They have held. I have right now. I can repeat their reply.
Your argument is once you determine to hold a disciplinary proceeding, how you can throw me out on the basis of 5-1. This is
5-1.
your argument.
Yes.
Show us that the authorities are stopped from initiating any disciplinary action. Then they thought it fit that we shall not proceed.
That is the strength of this order, Samshed Singh.
Show us which
Yes,
paragraph.
I am submitting. I have to read out the relevant paragraphs, man. Very fantastic reason has been made by the Honorable Supreme Court.
Only show us that paragraph.
Now, kindly come to page number, internal page 27, my lord.
27.
Citation, please.
Uh,
Rule 9. My lord, Rule 9, second paragraph, my lord.
Yes.
Rule 9 provides that there it is proposed to terminate the employment of a provision. whether during at the end of the period of probation for any specific fault or on account of the unsatisfactory record of unfavorable reports, implying the unsuitability for the service, the probationer shall be apprised of the grounds of such proposal and given an opportunity to show cause against it before orders are passed by the authority competent to terminate the appointment. Then, my lord, the position of a probationer, my lord, just 1, 2, 3 paragraph after.
Show us that portion which says that no inquiry can be conducted.
Yes, I am reading, my lord. Just, can you allow me some of the important line, my lord? The other is that if the termination of service is sought to be founded on misconduct, negligence, insufficiency or other disqualification, then it is a punishment. If the termination of
It's not founded on that.
Well, they have conducted an inquiry and they have formed an opinion that I have made a wrong thing and I am involved in respect of that. My integrity is doubtful. They have made a findings in the reply also.
Where is that?
If
Reply?
there is a findings, my lord, then I will get an opportunity.
Where is the
Yes,
where
my
is that finding?
Yes, I am giving the reply. The reply, Lordship, can you see?
Reply they have annexed.
The statement of the reply, my lord.
Uh-huh.
The statement of the reply.
Yes, that they have annexed to this application, na?
Yes, I am enclosed in the reply statement, who is in the original application, and they also enclosed, mother.
Reply is at page 121.
Yes, mother.
Page 125.
Yes.
They only say departmental entry duly conducted
Yes,
with findings. This is a wrong statement.
Yes. Paragraph 3, mother, page 127. With reference to the statement made in para 4.3 of the said application.
Where do you read?
Page 127, paragraph 3.
127.
Paragraph 3, my lord, and thereafter
127.
yes.
Where is the finding?
And page 133, my lord. Yes, my lord, page 131, paragraph 8, I am submitting, my lord. With reference to the statement made in paragraph 4.7 of the said application, the deponent state the learned lawyer is not aware of the fact that 12 January 2018 information received from the Colonel B.B. Bhatt, Director Recruiting Army Recruiting Office, Behrampur. Mr. Soumitra De of Army Recruiting Officer, Gopalpur, while on temporary duty with Army Recruiting Office, Behrampur, was caught illegally influencing candidates in the recruitment rally by the captain so-and-so and Havildar so-and-so, my lord. Later he reported, now they have made some findings, allegation against me, and thereafter, my lord, page 13, paragraph B. A departmental inquiry was ordered to investigate the illegal involvement of Mr. Soumitra De, temporary employee at Army Recruiting Office, Gopalpur, during recruitment rally being conducted at Krishnanagar, West Bengal, so-and-so. Now, these are the inquiry officers' name. The departmental inquiry duly completed with findings. Opinion of the inquiry term was forwarded on 15 February 2018. Thereafter, the same was forwarded by the Headquarters Recruiting Zone, Kolkata, and advice sought. The Integrated Headquarters Minister of Defense Army directed that on availability of sufficient evidence in the course of investigation conducted departmentally, necessary action should be taken as per para 3 of the appointment letter. Services are liable for termination on retention for 1 month notice, either by employee or the appointing authority, or by the appointing authority to the employee even without communicating reason for termination. Based on the above notice of termination, Rule 5.1 of the Central Civil Service Temporary Service 1965 was issued to Mr. Soumitra De. There is no response to the notice of termination of service Mr. Soumitra De was issued by the appointing authority on behalf of the Government of India on so and so date. And we reference to perhaps no appointment, so and so. Now, my lord, they have made a statement. There is illegality committed by the petitioner. Thereafter, they have recommended for regular disciplinary proceedings. They made an opinion in the preliminary inquiry. Therefore, if they made an opinion, I am entitled to get protection of Article 311 of the Constitution of India in terms of the Shamsher Singh judgment. If they do not make any inquiry, I will have no case at all. They have made out my case. Here the Honorable Supreme Court has said, the order is that if the termination of the service is sought to be founded on misconduct, here also misconduct they have stated, negligence, inefficiency or other disqualification, then it is a punishment and violates under Article 311 of the Constitution of India. The reasoning why motive is said to be irrelevant in that it inheres.
You are reading at page?
But I am reading
50.
Page 27, fourth paragraph.
All right.
Now, Lordship, I am reading, Mother. No abstract proposition can be laid down that where the services of a professional are terminated without saying anything more in the order of termination than that the services are terminated, it can never amount to a punishment. In the fact and circumstance of the case, if a professional is discharged on the ground of misconduct or inefficiency or for similar reason, without a proper inquiry and without his getting a reasonable opportunity of showing cause against his discharge, it may in a given case amount to removal from service within the meaning of Article 311(2) of the Constitution of India. Before a professional is confirmed, the authority concerned is under an obligation to consider whether the work of the professional is satisfactory or whether he is suitable for the post in the absence of any rules governing of a profession.
All right, Mr. Das.
Now, here, my lord,
any other point?
The professional is faced with an inquiry on charges of misconduct or inefficiency of corruption, and if his service is terminated without following the provision of Article 311, he can claim protection. Now, my lord, this judgment, there are other paragraphs are there, where it is very clearly stated by the Honorable Apex Court.
Yes, we understood. That is your contention. Anything else, Mr.
No, my lord, just a minute, my lord. Just two paragraphs I am reading. Yes. Madam, page number 63, madam.
That is your argument, Mr. Das. We understood.
Madam, here, madam, Supreme Court very significantly clarified that in respect of behind the back of the any inquiry is made. Here, my lord, your lordship has found they have hold an inquiry. If they hold an inquiry, then I am able to get protection of Article 311 of the 2 of the Constitution of India. If they do not hold an inquiry, simply see the tribunal, I will have no case before your lordship. Therefore, my lord, tribunal very cautiously has passed this order. My lord, kindly see the last portion of the order of this tribunal. The tribunal did not commit, it is their free hand. Tribunal did not commit any wrong, my lord. Kindly see. What is the last portion of this order? last page, paragraph 6 of the tribunal's order, my lord. None of the statement indicate that or other than a slip containing cheat bearing the applicant's serial number, nothing else was recovered from the candidates, whom the applicant allegedly helped. No evidence is recorded of any receiving money, etc. for personal gain. As such, the allegation that his termination was due to moral turpitude, discipline case dropped in purpose is not substantiated.
But termination was not for that. Come to the termination certificate order. Page 40. Forty 51. There is no difference of moral turpitude or there is no
My lord,
difference.
the wrong thing they have done, they hold an inquiry.
This is not there in the
My lord, wrong thing they have done, they hold an inquiry.
What is the finding of the tribunal? That I do not find any moral
But last portion of this order, Lordship Candice.
for ends of justice termination care cost.
With all consequences, with liberty to the respondent to initiate proceedings.
Yes.
With liberty, because tribunal has found out, they made an inquiry. They made an inquiry.
That you have argued. Paragraph 6, tribunal proceeded on a different track. Tribunal was allegation that his termination was due to moral turpitude. The wording is not.
Yes. And nothing has been recovered.
Where is moral turpitude, Mr. Das? Where do you find that word, moral turpitude?
But Lordship Candice is
আবার বলে but.
at the same time, tribunal has gave liberty to the department to initiate the proceedings. What the inquiry officer has held.
No, no, just proceeded.
And all the actions they have taken behind the back of the petitioner.
Anything to
But
reply?
I have to read out some portion of this order of some 16.
You have given it to us.
Because, my lord,
Your argument we have understood. Your
my
argument
lord,
is when
my
there is a,
main argument before your lordship, my lord,
how many times you will repeat,
my
Mr.
lord,
Rai?
just a minute, just some paragraph is very interesting paragraph is there.
Very good. We shall.
The judgment.
Pardon, madam.
You're talking about the judgment.
Yes, madam.
You give us the paragraph number in the judgment.
But here is no paragraph. I have downloaded from the server. There is no paragraph is there.
Give us the pages which you are reading.
My lord. First
You have
is, my-
showed us page 27.
yes, my lord. First page is, my lord, kindly see.
Don't take us through the entire judgment now.
No, no, no.
This is
Just 2, 3 paragraph. Page 5, paragraph 2 and 3. Thereafter, my lord. Page 11.
For
paragraph.
what? What is the proposition of law?
Proposition of law is very clear, my lord.
But you have said that. We have understood.
If there is an inquiry, then I will get a protection of Article 311 of the Constitution of India.
Yes, you
Yet, it is totally go by.
Yes, Mr. Bhattacharya, anything?
My lord, in reply, my lord, I will not take much time, my lord. But I'll just give my reply and I'll sum up also, my lord, on my submissions. My lord, the degree has heightened, my lord, after the judgment in Puttuswamy's case, my lord, insofar as, my lord, the right to reputation and right to privacy of a person is concerned. Now, stigma, my lord, also has attained, my lord, new heights. My lord, it is nowhere the case which has been made out by the private respondent herein that the order of termination is stigmatic. On the contrary, my learned friend has attempted to build up a case that the order of termination is not supported by the correct provision of law, which is applicable in case of the private respondent herein. My lord, I have taken your lordships elaborately, my lord, through, my lord, the rules, my lord, as also, my lord, through, my lord, the Government of India's, my lord, instructions dated 1967, to which, my lord, no challenge has been thrown, my lord, insofar as, my lord, the petitioner, the private respondent is concerned, my lord. The virus are not under challenge, my lord. It has been an action, my lord, which has been taken strictly in accordance with law, keeping the actions confined, my lord, within the four corners of the statute, my lord. And insofar as, my lord, this particular, my lord, the CCS temporary service rules are concerned, my lord, the rules also contemplate a situation, my lord, where during the period of suspension or, my lord, departmental proceedings also, my lord, Rule 5 can be resorted to. So that scope is also there, my lord, insofar as
I'll wait in for that.
My lord, even during the period of suspension or during the period of, my lord, pendency of departmental proceedings also, my lord, my lord, Rule 5 can be resorted to.
Where is that?
My lord, we'll find it, my lord. But the Rule 37 of the Posts and Telegraph Manual, my lord, that contemplates of a situation where Rule 5 can be invoked, my lord.
No, his argument was that, forget about his argument of 5-1. His argument is that when he's linking his ouster with the misconduct on the basis of which you recommended a proceeding.
And, my lord, I am saying, my lord, on the contrary, in reply, that, my lord, my learned friend should have concentrated more, or rather should have concentrated, my lord, in its entirety on the order of termination, which is there, my lord.
So according to you, there was no formation of any mind.
There is no stigma, nothing.
The letter provides that if he is not suitable, I can.
Yes, and he had an option of replying to it also during the period of 30 days notice. He chose not.
He made an
No, it is
appeal.
of a specific case, my lord, in affidavit, my lord, that we received it or we came to know about it for the first time, my lord, by virtue of the petition filed before the learned Central Administrative Tribunal. Nothing was received, my lord. Nothing.
Then he has annexed one document.
But that is the first time, my lord, when it came to our knowledge also, my lord. It is our specific case also, my lord.
Page 113, he
Yes,
made a
yes.
representation.
No, my lord, we have never received that. That is our specific case, my lord, in the affidavit also, my lord. Please find
This
out.
letter you have not received.
No.
13 June
No.
2018.
And, my lord, on the contrary, we have said that he could have sent it by way of registered post also.
No, this is 13 June 2018.
Yes.
Your termination was, notice was 11 June 20.
My lord, kindly takes page 135, my lord.
11 June 2018, and that was July. This is in between 11 June he replied.
My lord, kindly takes, my lord, page 135, my lord, of the petition.
You said that you have suppressed.
No, we
They are-
said that we have never even received anything of that sort. Paragraph 9, with reference to the statements made in paragraph 4.9 of the application, the deponent states that he is not agreed to averment as stated and further submits that neither Director General Recruiting Integrated Headquarters of Ministry of Defence nor Deputy Director General Recruiting Headquarters received any such representation. Mr. Soumitra De could have handed over his representation application through registered post or to any army recruiting office, Gopalpur itself, or by hand to the headquarters recruiting zone. Same was received only as an enclosure with the petition dated 28 September 2018 on 3rd of October. That is when the application filed before the Central Administrative Tribunal was received by us.
Yes.
And also in the representation, my lord, which he has annexed, my lord, it is a representation dated 13th of June 2018, in which he is challenging a decision of 13th of July. So we can well understand, my lord, how the representation, my lord, saw light of
11th of June.
No.
Then he made it on 13th of June.
No, but if one kindly takes my lord, the representation.
Yes, that is at page 113.
Yes.
That is on 13th of June.
Yes. My lord, kindly sees, my lord, 13th of June.
Huh.
Now, my lord, kindly sees, my lord, the subject to quash and or set aside the impugned notice of termination dated 11th of June, as well as the impugned final order of termination dated 13th of July. So on 13th of June, my lord, he is challenging a decision of 13th of July.
Just like your supplementary affidavit, you have enclosed the documents by
Mr. Das.
changing the date.
So you will do so?
No, I will not.
Also do so.
But they are also kindly see, they are integrated hospitality, the army department.
All right. Yes. The learned advocates appearing for the respective parties have concluded their arguments. Stop judgment reserved. এটা আমাকে দেখিয়ে দিন। কার্তিক, দিতে পারবো।
But only page 27 and 28. Just one sentence. Page
Paragraph
27 and 28, first and second paragraph. Second and third paragraph.
In
Totally
Francesi.
27 and 28.
I'll read the whole judgment for you.
All right, it is just, it has been clarified by the Honorable Supreme Court. Page 27, my lord. Paragraph 5, 6.
Read it out.
You have, how many times will you read page 27?
Paragraph, last 3 paragraph.
How many times you'll do so, Mr.
No,
What you are pointing out here?
This is cover everything.
Page 27. Yes.
I am grateful, my lord, to your lordship, my lord, for the patient hearing, my lord, and for bearing with me, my lord, for the trouble caused, my lord.
Yes.
Number 86. Number 26, Lord. Time for the petition, the last petition, Lord.
What, you want time?
Lord, this was.
You mentioned that the. No? What to put? No.
Lord, 26.
Similar lines I did. I set aside those, I directed back pages also. The back pages part was interflated. Better is paid. I can give you a copy of the judgment so that you can. Yes. এই শোনো এবার পার্টটা কাটিয়ে দিও শোনো
Milord 26, I am for the petition, Milord.
Yes, sir.
Milord, your lordship kindly adjourn it, Milord, till 2 weeks after vacation. Because of the reason, Milord, the following the guidelines, Milord, his application was dismissed. By
You are for the steel authority?
Milord, yes.
Huh?
Yes. But this
Next monthly list. Yes, next.
after 2 weeks, my lord.
Next monthly list. এটা শোনো, এটা ফরওয়ার্ডার্সে আছে তো, এটা ট্রাইব্যুনাল, এটা হিয়ারিং এ ঢুকিয়ে দেবে। না না, দেখি ফাইলটা তো একটা। Mr. Bhattacharya, learned advocate appearing for the petitioners prays for an accommodation today. Stop. Please the matter under the list the matter for hearing in the combined list of this court. In the combined monthly list of this court of January 24. হেডটা ডিফারেন্ট আছে তো, আবার এসে ভীষণ তর্ক করে।
28, my lord, kindly recollect that it is a matter, my lord, with regard to the state filed the appeal. The matter regards to that, my lord, that the pre-1996 retiree of the my lord, today, yes, Mr. Prasad. Now, my lord, it fell from your lordship that let the matter appear today, then a date would be fixed for the purpose of, my lord, the date for the hearing. And my lord, in the meantime, a liberty was given to me, since no affidavit was filed. None appeared before the learned single judge. No affidavit.
Where is Mr. Prasad today?
Yes. And my lord, another thing is this, my lord, that apart from that, the liberty was given to me that I can produce any document by way of supplementary affidavit. Now, my lord, I sought for certain document from CSTC because they rely upon CSTC documents. So, my lord, I think, my lord, I will get it within 2 or 3 days. I'm told CSTC. I can file my affidavit annexing that document.
Was there any direction that you file?
Yes, there was a direction. And my lord, another, my lord, aspect in the matter is that
This is the retirement benefits.
Retirement benefit. Only that what should be the, my lord, the calculation of their pensionary benefits, the amount, the quantum. According to them,
We keep it next week, come with whatever you want.
my lord, kindly, my lord, take it, my lord, after a fortnight. Lordship, kindly. Why I am telling before your lordship? Now, my lord,
We'll again go in the combined list, the problems.
no, my lord, may I tell, my lord, because now, only, my lord, the 2 days back, NBSTC informed the, my lord, the state government that some of the, my lord, the petitioners who filed the writ petition, they died. And my lord, their heirs are to be substituted now. But that application, I will make it ready. That's a very formal application will be. Only thing that she kindly, my lord, take it in the month of January, my lord. I think everything will be.
ওটা কেটে লিখে দাও। Mr. Sen, learned advocate, appears for the evidence, but no one appears today on behalf of the response. Heard Mr. Sen, learned advocate, appearing for the state petition, WBC stop. No one appears today on behalf of the stop. This the matter for daily supplementary list of this court on January 5th.
Get, well, I shall communicate it to Mr. I shall inform him.
I am for the petitioner, my lord. On the last occasion, my lord passed the order by directing the respondent to file affidavit in opposition within 1 week after vacation and reply thereafter. But no copy has
Lordship, I appear for the state, Your Lordship. Mr. Rai Mukherjee is appearing for the state. Your Lordship, there are certain documents that are required to be produced, and on that basis, the affidavit would be prepared. I'm asking for a week's time, Your Lordship, and I'll be profiling my.
How long time will you take?
Your Lordship, the last quarter, October, Your Lordship. We've written to the authority concerned. There's a few documents that are required, and therefore Mr. Rai Mukherjee has instructed me to seek a week's time. He's on his leg before another bench, therefore, Your Lordship. I'm not on the panel, therefore, I'm stating that at the very outset. It's a state matter, Your Lordship.
The learned advocate appearing for the respondents prays for extension of time to file the affidavit in opposition. Stop. Let such affidavit in opposition be filed within a week after the vacation. Reply thereto, if any, be filed within a week thereafter. Establish the matter for further consideration 2 weeks after the vacation.
My lord, fix the date, my lord.
Yes.
Kindly fix it.
This the matter for
Fix the date and last chance, my lord. They have taken many times.
daily supplementary list of this court on 22nd January. 22nd January.
Grateful.
Grateful, my lord.
Your Lordship, I'm not in the panel in this matter, so I still give my name.
Doesn't matter. You're appearing. Give your name.
But Lordship, kindly some give accommodation in this matter.
Lordship, this is the matter where whether there was a notification under section 14(2) of the Administrative Tribunals Act.
Yes, yes,
Lordship,
yes.
and on the previous
But
occasion.
my client has submitted one letter to me. And I call my client to come before me with some material instruction, Mother. Till now, he did not turn up.
Because
That is the main thing.
last
Last
occasion,
occasion also
there was
it was submitted that you do not want to do the matter,
Yes.
wants to withdraw.
Therefore, Mother, if he doesn't come, Mother, how I have to submit a letter before this court. I have called my client over telephone, Mother. That is the problem, Mother. Give some 2 weeks time, Mother. In the meantime, I shall.
Section 14 of the Administrative Tribunal Act that to bring the organization under the within the jurisdiction of the tribunal, there has to be a notification. And that notification is not there in respect of ICF, this organization. But previously, when the same point arose, they did not take this point. This is a continuation. The thing is, even if we consent and submit to the jurisdiction, still there can be a jurisdiction. And can't consent to it. Not touching it. That's to be Mr. Das, you, what is the use of keeping the matter pending?
Malad, my client has
We
requested.
will allow her prayer then.
No, Malad, I said withdraw the application before the tribunal. Everything will go.
Which tribunal?
Before the central tribunal. My case, it is the interlocutory order, they have come. Matter is pending before the tribunal.
He has to file another case.
Matter is pending before the tribunal. Since my client will be retiring, Malad, they are saying, if you do not withdraw this matter, we will not give the settlement dues. For that aspect, Malad, he has asked me to withdraw this matter.
To withdraw the
But I have asked him to give a letter.
Not this matter, you withdraw that
Yes, a
original
tribunal,
application
yes.
finished.
Yeah, that is the main thing. That's kind of.
Otherwise, Miss Alam will argue that you decide the issue of jurisdiction.
That is true, Malad. That is.
We cannot give indefinite time for that.
No,
Last
that
occasion,
I pray 2 weeks time, Malad. After that, Malad, everything I shall take care in this.
Because on the previous occasion also they had.
He's not giving the letter. That is the main thing, Malad. I have to
Then
follow
maybe
this
he
letter.
doesn't want to withdraw, Lordship. Then
How advocate will submit that he will not be.
an adjournment has been prayed for on behalf of the respondent, though Miss Alam, learned advocate appearing for the petitioners, is present. Stop. As a last chance, the matter stands adjourned. List the matter for further consideration in the daily supplementary list of this court on 12th January.
12th January.
If you don't bring it, we proceed with the matter.
What
This is
January?
understood.
12th January.
Yes.
Deeply applied.
You withdraw the application or file an application and
Yes,
show
yes,
it to
I
us.
shall give the letter.
Lordship, 12th January is probably a holiday, so I think the date has to be.
12th will be a holiday.
Probably it's
16th করে দাও, 16th. No, they declared that gist is given from fixing the desert
in this-
calendar and not come. No, but that the purport better. That calendar which has been given there will be approved. Or that will be circulated in ourselves. Probably this month. Yes, yes.
So I am for the
The
PT.
next one. Yes.
So I am for the writ petitioner, my lord, in this matter.
My lord, in this matter, I am for the respondent. My lord,
Sir, don't pray for adjournment. These matters.
no, only, my lord, 2
want
days
to-
time. My lord, kindly keep it at Thursday at 10:30, my
Thursday,
lord.
we are closing down, sir. We are closing on
My
20.
lord, Thursday at 10:30, my lord. My lord,
No,
I
it cannot
actually,
be as per your desire, na?
no,
Cannot
not
be
at
as per
one.
your-
I am submitting before your lordship. I humbly submit before your lordship. My lord, actually, some necessary instruction I have to take, my lord. They have, I have not been able to do take it up till now.
A paper,
Kindly keep it Thursday, my lord.
the paper book has been filed, my lord.
Kindly keep it Thursday, my lord.
The person is suffering, my lord, since 2014 without.
We are also suffering. We are also suffering. Not today.
Tomorrow.
My lord,
You desire to take it at tomorrow, man.
my lord, kindly keep it Thursday, my lord. Kindly, my lord. I beg to you, lord.
Thursday.
Get.
Thursday, my lord, let it retain its position. Only this, because I
Please bring it up. Yes.
some urgencies are there. That is the reason, my lord. But you will
Yes,
remember
for the
that.
next. Let us see. Let us see.
Get.
32 I appear. And then 1 and 2. Employed with the West Bengal Financial Corporation. But he retired, my lord, on the 31st of.
The affidavits are complete.
My lord, affidavits, my lord, all the documents are on record having regard to the fact, my lord, directed the matter to be, my lord, heard on the basis of materials on record. That is my lord's order, my lord.
My lord,
Those
before the
affidavits-
learned single judge, my lord, affidavits were exchanged, my lord.
Oh, I see.
And they have been annexed to
those-
the petitions 27th September 23, my lord's order.
Yes.
Now, my lord, the petitioner before my lord, he was an employee of West Bengal Financial Corporation. He retired on the 31st of December 2020. But his retirement dues have been disbursed except for the fact that, my lord, the gratuity of 20 lakhs, my lord, instead of that, he has been paid, my lord, a gratuity of 12 lakhs. My lord, West Bengal Financial Corporation, my lord, has an actuarial contract with LIC India. My lord, this actuarial contract, my lord, is to ensure that as and when, my lord, there are revisions of gratuity in terms of the Payment of Gratuity Act, my lord, the enhanced premium would be communicated by the insurance company, my lord, to the West Bengal Financial Corporation, and my lord, the enhanced, my lord, payment premiums would be paid, and the gratuity so enhanced, my lord, would be paid to its retired employees. For this, my lord, a trust, my lord, has been created, my lord, of the West Bengal Financial Corporation. This board, my lord, has entered into the actuarial contract with LIC. Now, my lord, when the 2018 amendment to the Payment of Gratuity Act, my lord, came in, my lord, the gratuity ceiling was enhanced to 20 lakhs. West Bengal Financial Corporation, my lord, took a resolution that its employees would be paid 20 lakhs. Accordingly, my lord, it pays premium to LIC. My lord, Life Insurance Corporation, my lord, settled dues of some of the retired employees of the corporation at the enhanced rate. Suddenly, my lord, West Bengal Financial Corporation, my lord, thought it fit that a nod from the state government may be required. So it writes a letter, my lord, to the West Bengal state government. Now, the state government was not replying. My lord, the retiring employees, my lord, they start writing to the corporation. They said that we have asked for an approval of the state government. This, my lord, kept things in abeyance for some time. Ultimately, my lord, it so transpired that a decision has come of which the employees knew nothing, but the corporation was informed whereby and whereunder, my lord, the state government declined to grant its approval to the enhanced limit of 20 lakhs.
No, what role the state has to play?
But the state has no role to play, neither under the statute, nor it shoulders any financial responsibility. But the affidavit of the West Bengal Financial Corporation, it unequivocally would go to show that the corporation has taken resolution and is supporting the cause of its employees that the enhanced gratuity limit should be respected. Because it is entirely between the corporation and the company which is shouldering the financial liability, that is the insurance company.
Come to the ordered implement.
Look, page 137. May I read, my lord? This would be 24th of June 22. Huh? August. Yes, yes.
You are the appellant, no?
But I am the appellant. The petitioner is a superannuated employee of West Bengal Financial Corporation, being the principal respondent. The prayer of the petitioner is enhancement of ceiling of gratuity payable to the petitioner on superannuation from 10 lakhs to 20 lakhs in consonance with the Payment of Gratuity Act 2018. According to the petitioner, if the ceiling of gratuity is set at 20 lakhs, I'm sorry.
Since the already declared the proposal notice for the absence of specific value. He says that state has no role to play. That is what he says. State government has no. So, Mr. Chaudhary, why didn't you prefer the writ petition challenging the state government order? That is why it seems to be an innocuous order, Mr. Chaudhary.
No, kindly, my lord, see my prayer. I have challenged. Kindly see my pleadings first, my lord. My lord would kindly come to page 29.
No, is it your contention that that was already challenged?
It is under challenge. The date is not mentioned because we did not know the date.
No, that came subsequent to filing of writ petition.
No.
Oh, that was not known to you.
It was communicated because, my lord, the Financial Corporation adopted a resolution and it asked for an assent of the state government.
Right.
The state government communicated the corporation. By the time I had retired, I had no knowledge. I sought information. Information is not granted, my lord, as regards the status.
So have you brought this on record before us?
Yes. It is the affidavit in opposition of the, my lord, respondents. It specifically, my lord, brings in the record which is the subject matter of challenge of the decision. I have said any decision
for the state government.
My lord, I have served notice, my lord.
State is the then.
My lord, I'll to cut the matter short, my lord.
Yes.
If your lordship kindly sees, my lord, the order sought
appearing
to.
for whom?
I am for the respondent number 1 and 2, West Bengal State Financial Corporation and its officer, my lord.
Yes.
Now, my lord, to cut the matter short, my lord, I'll tell your lordship. If your lordship, my lord, sees, my lord, the order sought to be impugned, your lordship will find that there is a specific mention of section 48 of the State Financial Corporation Act. Now, my lord, apart from that, section 39 is also, my lord, comes into play, and a combined reading of that will show that, my lord, whatever regulations, whatever policy decisions, including, my lord, the decision of, my lord, disbursing, my lord, the additional sum which the petitioner is seeking, my lord, before your lordship, has to be done, my lord, by the state government, my lord, finance department.
So
now, my lord,
what were you doing in respect of the other?
we have, my lord, written to the the finance department of the state government, my lord, but they have
previously also you were paying.
My lord, previously it was 10 lakhs, my lord, and my lord, in accordance therewith,
20 lakhs have been paid. I show
that was having the approval of state.
My lord, 10 lakhs with the approval of the state. That was, my lord. That is
here. The issue is that the state is not a state. State has no role to play. It is
my lord, it is the state government, my lord, who has to take the decision.
Please serve upon the state and government.
I shall serve again, but I'm surprised. the affidavit in opposition and the resolutions is that, my lord, the corporation was pitching in favor of its employees. They have adopted the resolutions of payment of 20
Exactly,
lakhs.
that is-
But kindly, my lord, kindly seize for a moment the document. But today, since my lord is desiring that I should state this,
That is subject to.
Complete hearing, no?
yes, I shall serve the state once again.
And what is my learned friend saying, my lord? That is subject to, my lord, the decision of the state government. That is clear from the, my lord.
Exactly what we have
Yes.
told him. But who is engaged on behalf of this?
Now the state has also given its assent.
Given its
Assent.
assent has been given.
My lord, kindly seize.
If, my lord, the state allows, I do not have any difficulty.
This is during
This is the
Then,
trump
the,
card
of
he's
course, my
bringing
lord,
at last
if the
meeting.
assent is given, my lord,
My lord, because I was not expecting the corporation to stand in the way.
I am not standing in the way, my lord. ওখানেও তো স্টেট আছে
So this is in your favor.
Yes.
Then what remains, Mr.
Nothing but the presence of the state, if my lord so desires.
My lord, subject to your lordship's convenience, my lord, may I suggest one thing, my lord? Humbly praying, my lord, if your lordship kindly, my lord, keeps this matter, my lord, after the vacation for
Why
a
it
day.
is matter is his matter.
Yes.
He says that I have got the benefit.
But, my lord,
What's your problem?
No.
There's a memorandum has been passed, my lord. My lord, I do not have any, my lord, idea about this, my lord. I need to take instructions and come back, my lord.
But the corporation has got no role, my lord.
Exactly.
Except for the fact that it wants the case to be referred.
So therefore, my lord, the state has to come.
Any which way you want a time.
But have you seen it? You are aware of
My
this?
lord, Lord, I have not gone through that memorandum, neither I have any instruction with regard to
Mr.
that.
Chaudhary,
But
then
nonetheless, my lord,
file a short supplementary affidavit enclosing.
I shall.
And you serve upon the parties, we decide it. If this solves your problem, we will listen.
And-
to the
and in addition to this, my lord, it should be, my lord, brought to the notice of this honorable court. We have again, my lord, written to the finance department seeking for their response, my lord.
So, sir, your client does not contact you. This is a letter of 14 September 2023. He
After,
is suffering. He is suffering. You are not suffering.
my lord, kindly appreciate, my lord, I have written to the state government. The state government has denied it. I have nothing to do.
No much water has flown after that. The state government has. When did you write to them? When did you get
Recent,
the
very
denial?
recent. কবে
It must be prior to 14 September.
No, after that. After that.
Show me the letter. How can they do
Achha.
that? No.
My lord, the copy of the letter is not with me, my lord.
Cannot be.
Can't be.
After 14th
When
September.
the state has taken a conscious decision, they can't go back on it.
And what is your problem if he gets
No, nothing. Nothing.
You should be happy.
If there is a direction upon the state government, my lord, I shall disperse it.
Mr. Chaudhary, learned advocate appearing for the appellant, file a supplementary evidence. এটা একটু ওনাকে ফেরত দিয়ে দাও, ওনাকে ফেরত। Let such supplementary affidavit be filed within a week.
Yes,
or
madam.
after vacation.
No, kindly, my lord, on this side of vacation, he's suffering.
This side of vacation, I don't think possible.
This is, my lord, will not take more than 10 minutes of my lord's valuable time. Lord, I am suffering, my lord. This is my gratuity, my lord.
We are only 9 days from the vacation.
My lord, one of those.
My brother won't be sitting with me in the next week. My brother wants hearing with me because new bench partner would come, because the original bench was with Justice Velumoni. My lord would be returning with to criminal side.
My lord is always assisted by able judges, my lord. No difficulty. My lord being there, my lord is always assisted by able judges. So there is no difficulty.
That I have no doubt about.
My lord.
There is
One of those 9 days,
more
10
able
minutes of
than
my lord's
me,
valuable time.
more able than me. Contention ought to have been like this. Pressure to file a supplementary, let's say supplementary affidavit be filed.
সাপ্লিমেন্টারিতেই তো তুমি
within-
কপিটা পাবে।
Let's say supplementary affidavit be filed within a week from date, leaves the matter for further consideration in the daily supplementary list of this court on 20th December.
No, except 20th.
Within a week from date with copies to the learned advocates appearing for the respective parties. Establish the matter for further consideration in the daily supplementary list of this court on 3rd January 2020.
As a lordship, please.
Yes. As no one appears on behalf of the state respondents today, comma, the appellants are directed to intimate this order to the learned advocate who has already been engaged on behalf of the state. Yes, next. Chalo, let us rise. Take it.
20th, my lord, would be a day dedicated to my father. He died a year ago, so it would be the death
So
anniversary.
where is your other side? He has left.
No. My lord has not fixed 20th. My lord has fixed 3rd January. My lord was fixing 20th. I said no. That may I justify myself.
Then we keep it in the list. Where is your friend? He has left.
Where he is.
Ask your clerk to go and ask.
My lord. My lord has fixed it on 3rd. 3rd is fine, my lord.
No problem.
No. I said why I said no for 20th. My lord was fixing an early date. I justify myself.
But if you want it on 21st,
I was just thinking the other way around, that I have refused to it to be on 20th.
No. Could it be 21st? If it could be 21st, my lord.
21st.
21st.
Let it be there on 21st. If you have problems, come on.
I'm grateful, deeply obliged.
You file it and serve upon this.
I shall.
Yes.